Good morning and welcome to the Standing Policy Committee on Property Development. This is our appeals meeting that we have. We have double the fun in property and development. We were just talking about that. But before we begin for this meeting, I want to introduce myself. My name is Councillor Sherry Rollins. I'm chairing the meeting today. With me is Councillor Wyatt, Councillor Eadie, and Councillor Schreier, and Leah Cowan, the Senior Committee Clerk, who you would have talked to in advance of the meeting. I'd like to acknowledge that we're on Treaty 1 territory, the home and traditional lands of the Anishinaabe, Innu, and Dakota peoples, and in the national homeland of the Red River Métis. Our drinking water comes from Shoal Lake 40 First Nation in beautiful Treaty 3 territory. I'll need a motion for the minutes from the previous meeting. Oh, none for this meeting. I'm in the wrong meeting. But we'll start with the first appeal. Yes. Oh, yeah, we're going to make a brief change to the agenda. We'll go through items 1 to 4 and then go into item 6, and then we will end with item number 5. We'll need a motion to change the agenda. So moved by Councillor Wyatt. All those in favor? That was carried. The first appeal.
Okay, in accordance with the City of Winnipeg Charter and the Development Procedures Bylaw, the process the committee will follow is the appellant will be heard first, followed by those in support of the appeal. Next, those registered or in opposition are heard, followed by those registered for information. Finally, the appellant may return to speak in rebuttal to comments made. However, no new information is permitted. Please note that when your name is called, it is your opportunity to speak. However, you are not obligated to do so. Item 1 is an appeal under the Planning, Development and Building Fees Bylaw number 66 of 2016 at 654 Kildonan Drive. And item 2 is a similar appeal for the same address, councillors. If there is a brief summary from the public service.
Good morning, councillors. Thank you, Madam Clerk. We are the first two here are for 654 Kildonan Drive. The first one being a fail to correct defects fee in $174. And the second one being for fail to finish work fee of $230. So the first fee of failing to correct defects, this appeal is before you as a result of a decision from the Planning Property Development Fee Waiver Committee from June 4th of 2024. That fee in question, as I said, is for a non-compliance fee in the amount of $174. A series of defects were found during electrical inspections. There were 2 of note, one being an arc fault protection missing for interior and exterior receptacles that was found on September 29th of 2023. That was to be corrected within 30 days, meaning before October 30th of 2023. The other defect was a missing junction box cover plate with the same 30-day time frame. These were not corrected until October 18th of 2024, so over a year later. Our system generated email reminders, and those were sent to the permit applicant, which was, in this case, the contractor. And those reminders are sent via email. They're automatically sent, and the Fee Waiver Committee at the time in June relied on Section 7.4 of the Winnipeg Building Bylaw, number 4555 of 87, which says every constructor is responsible jointly and severally for the owner or with the owner for any work actually undertaken. And on the actual building permit, there are conditions, one of which being is a note that says fail to arrange reinspection of defects within 31 days will result in a non-compliance fee being issued. So essentially what we have here is a dispute between the contractor and the homeowner on who is responsible for not calling and not having that defect called for correction and reinspection. So we feel that the Fee Waiver Committee was correct in denying this one.
How much is the fee?
$174 for the first one. The second one is $230.
The second appeal?
The second, there's two charges here today before.
Because there's another appeal relating to the same property on item 2.
Right. So the first one, $174. Number 2 that you have is $230.
Are we hearing them concurrently?
Pardon?
Are we hearing them concurrently? Yes. We are?
You can hear the representation on both, and then there will just be separate decisions on each.
So we're not hearing them concurrently?
You can hear the representation for them both together if the committee.
Oh, I
wishes.
see.
It's the same
We can,
address.
okay.
Okay.
So we're here, is there an application fee to file an appeal?
No.
I see. Why not?
It's not part of the process at this time, something we could examine.
What was the question?
Is there like a $25 or $50 non-refundable fee to make an appeal?
Not for our appeals, no.
Not a bad idea. Deal with some of these.
Okay, so that is a different time. We'll move on if there's no further questions related to this appeal. Okay.
Actually, could you tell me about the waiver committee, the fee waiver committee?
Sorry, what would you like to know?
What is the fee waiver committee?
It's an administrative committee.
Okay.
Yeah, it's an administrative function within planning, property, and development that is assigned by the director, and I'm the chair. I sit as the chair of that subcommittee, and we hear appeals from homeowners or permit holders that don't agree with decisions made on non-compliance fees.
Thank you.
Any further questions, councillors? If not, we'll move on.
Okay, so the appellant, Keith Young, has not registered to speak today. Just confirming that there is no one in the gallery that wishes to speak in support of or in opposition to this appeal for 654 Kildonan Drive? No? Yes. They were emailed and sent notice.
Did he ask for a different date?
Originally, at the last hearing, yes, at the November 14th hearing, they indicated that they were unavailable, and they were sent notice that the hearing was adjourned to this date. The notice was mailed and emailed on November 15th, and no further
Did we hear anything
communications.
back from him?
No.
Okay. Seeing Mr. Young was to appear on behalf of Neil Spence. Is there anyone else to speak to this appeal?
No one has registered, no one in the gallery speaking to this appeal?
Anyone online?
Nope.
Okay.
Excuse me.
Chair wishes?
Just one second, and then I'll recognize you, Councillor Wyatt, Councillor Schreier.
Sure, it's on behalf of Neil Spence. Keith Young's meant to be here on behalf of Neil Spence. I'm told that this appeal is made by the contractor, therefore Neil Spence is the contractor?
Neil Spence is the homeowner.
Okay, Neil Spence is the homeowner.
Yes.
Keith Young is the contractor?
No.
Okay,
Just someone representing Mr. Spence.
something representing Mr., okay.
Any further questions, Councillor Schreier?
No, thank you.
Okay, Councillor Wyatt.
I'm going to move that receipt of public representations be concluded.
All those in favor?
Aye.
Carried unanimously.
I'm going to move that the appeal be denied and the decision of the fee waiver committee of the Planning, Property, and Development Department be confirmed.
All those in favor?
Aye.
Carried
I'm going to move that
unanimously.
the appeal hearing with respect to this application be concluded.
Okay. All those in favor?
Aye.
Carried unanimously.
Please note that the committee has made a final decision on this matter, which is not subject to further appeal. And then if the committee would like to move motions with respect to the second matter at this address?
We have a mover for number 2 at 654 Kildonan Drive.
All right. In light of the fact that there are also no delegation here in terms of Mr. Neil Spence or Keith Young, I'm going to move that receipt of public representations be concluded.
All those in favor?
I'm going to move that the appeal be denied and the decision of the fee waiver committee of the Planning, Property, and Development Department be confirmed.
All those in favor?
Aye. I'm going to move that the appeal hearing be concluded.
Before I call the question, I'll just add my supporting reasons are in line with the public service. All those in favor? Any opposed? Carried unanimously. We'll move on to item number 3, an appeal of the Planning, Development, and Building Fees Bylaw number 66, 2016, 4856 Selkirk Avenue. summary from the administration.
Thank you. This appeal is before this council as a result of a decision, again, of the PPD Fee Waiver Committee from October 1st of 2024. The fee in question is for inspector unable to gain access. It's a non-compliance fee in the amount of $182. During that inspection, or a previous inspection, a series of 13 defects were found during that inspections process in January of 2024. On the report provided in the exhibit, there is a screenshot that lists the 13 deficiencies, and notably the code requirements for handrail at a front landing, mechanical room door, and primary suite door not being smoke tight, along with a number of other defects that were determined to be lower. The handrail is deemed to be a critical, and the smoke tight is also important there. So the deadline for correcting the defects was given to be June 5th of 2024. A reinspection was not called for until after June 5th, which the inspection didn't actually occur until August 9th of 2024. The applicant is relying on the difficulties in coordinating with tenants as a factor in why the delay occurred in obtaining the final inspections. At least that's what they've indicated in their appeal. And this, for the department, is not an accepted rationale for failing to arrange a final inspection. It is incumbent on the permit applicant to manage their permits in accordance with the Winnipeg Building Bylaw, number 4555 of 87, and any other relevant bylaw or code. The department further notes that owners placing tenants into spaces under construction that prior to having passed final inspections is a risk borne by the owner. Section 14.1.5 of the Winnipeg Building Bylaw states that every permit is issued upon the condition in Part B that work shall be carried out in accordance with all provisions of the bylaw and the code and all provisions as described on the permit. And on the permit, again, as the previous applicant, there is a condition that says that failure to complete work or failure to adhere to all the conditions of the bylaw will result in non-compliance fees. And in this case, we are asking that the department, or we submit that this appeal be denied and that the decision of the Fee Waiver Committee be upheld.
Okay, thank you. Any questions at this juncture?
How much was it?
182.
$182, 182.
Any further questions? Councillor Edie?
Yeah, I'm just, so the cause cited by the appellant was coordinating with the tenant. Do we as a city know what the landlord tenancies branch rules are related to entering a premise if there's health safety problems that have to be dealt with? Like the handrail is a health safety issue, right? So,
Well, it's a code issue. It's not, we're not looking at it from the health and safety lens. We look at it from the building code issue, from this building code lens. And that's part of the permit and part of the inspections process. And that's the only area that we're focusing on. So in this case, the defect, or we weren't able to gain access for the reinspection on that day, which is a violation and results in a non-compliance fee issued.
right. So we don't really care what the landlord's rates are to get in there versus the tenant and the permit.
Through you, Madam Chair, it's not that we don't care, it's that the arrangements are with the owner or the permit holder to make. It's not for the department to stick handle that for them.
All right. Yeah, okay.
What's that, Ron?
We're going to hear from the appellants.
Any further questions? If
Yeah,
not,
how long has that been
yeah.
the building code?
I'm sorry?
How long has it been the building code? Does the building code include the
I don't
stair-
have that information handy.
Okay. I assume so. I just know that insurance, not the building code, but for insurance, that's changed
Okay,
in more recent
we
years.
move
I think this
on?
is longer.
all right, we'll move on. unless there's anything further, you guys? Okay.
Okay, so the appellant, Mally Olak, has, oh, are you here in the gallery? Yeah. Okay,
Perfect.
so you can come down to the podium.
Got stuff all in my glasses. Not doing everything. I've got it.
So you have up to 10 minutes to speak, but you will need to fill out a registration form. You can do that
Because
once
I have
you're...
issue with my eyesight because I went through actually 5 operations because I told the guy.
Do we need to? Okay, start early. Good morning, Mr. Olak. You're with committee. You have 10 minutes to discuss your appeal. It's on. Your microphone is on. You needn't touch the microphone unless you're adjusting it for height. It's on. Go ahead.
Can I speak now?
Yes.
Good morning to all of you. I guess the reason I'm here because I think the fee waiver committee from PPD, they refused, I guess, to waive the fee. I think I explained to them in detail what was the reason at 856 Selkirk. First of all, because of the location of the address or the house itself, there was a vandalism so many times. I guess the owner has to get the windows changed and all the other stuff because even he tried his best to make sure it is insured properly. But I think my understanding by talking to the owner, the inspection was arranged, and at that particular time, the house was sold to the to the home buyer. And then what happened when the inspection was scheduled, the owner made the arrangement. I hope you can hear, I guess. Then I guess the owner made the arrangement for the access for the inspector to go in there for the last inspection. What happened in the meantime, the owner, I guess the new owner had a tenant in there, and he mentioned to the tenant that there will be inspection or the inspection is scheduled for such and such day, such and such time, that please be there. And he assured the owner that he will be there, but when the inspector actually showed up there, so he took off. He was not there. That's exactly what happened. Then we thought maybe under the circumstances, although I think it is not the fault of the owner, in a way, you could say that maybe because that was previously his house, but the house was actually purchased by the purchaser, and that was actually the responsibility of that person. And again, the owner made it pretty clear, and he made all the efforts to make sure the inspector will have access to go in there. That was the last inspection. That's when they said, well, because the guy went there, he was not able to access the property, And that is the reason actually they're going to impose $182 fee for that re-inspection. So I was not sure actually because then I explained this in my documentation that was sent over to the PPD fee waiver committee. And then I got the decision that it's basically even based on the circumstances. In my opinion, I guess because I can only tell you what I think. I mean, I spoke to some other people too, because it happened under the circumstances. In my opinion, the waiver committee from PPD should have actually given the favorable decision. That means it should have waived. Now that is the reason I'm here. So although I think it's not actually a matter of money in a way, but I think it's a principle based on the experience with other people dealing with the city all the time. And again, from my experience in my life with working with the city, municipalities, and all the other, government identities. So basically, I thought maybe it was very reasonable in my opinion, to consider that decision so that the fee, which is $182 inspector not being able to go into the property, and I just explained to you the reasoning, what was the reason, and then I thought maybe it was well a reason for committee to give a favorable decision to waive this 182. And I request the committee that they reconsider this, my documentation that was submitted over to the PPD committee. Although I think you do not have that information, I have to apologize also because I got sort of misplaced the documentation. I should have sent it over to the, clerk on Friday, I think Friday by noonish. But that is the reason I sent an email over to her last night, so I have to apologize for that. In the meantime, I will just leave up to the committee for their decision, and hopefully it will be a favorable decision based on the circumstances. Thank you very much for your time.
So if you have documentation, sir, hello?
Yeah.
If you have documentation that you want to review orally, you may do so now. You have additional 4 minutes.
Oh, I can actually, if you want, I made some copies. Will it be appropriate if I I made a couple copies of that? Will it
Like
be?
I said, you can review it orally. If there are facts you want us to know, if you can briefly describe those facts. We do have a description of the reasons you provided the fee waiver. What you've covered now is very similar to what we have before us. Reasons you provided the fee waiver. If there is something more or different you want us to know, i.e. the documents that are in front of you, you can describe them orally if there are different points of fact than what you've already provided.
No, I thank you for, excuse me, for the extra time, to explain to the committee. I think I did explain already what exactly happened. I think again, and I guess we did the designing of that house, because of the location or the area, because the owner actually lost a lot of money because of vandalism and all that, but the owner made, every effort to make sure it's properly secured so that once the construction was going on, there won't be any problem, but still there was some, issue. So beside that, every time there was a deficiency list, I reviewed the deficiency list. It was actually done within the time because I need to actually tell the contractor through the owner that they must comply with the bylaw and code, and it is critical. And I think it was done. And again, so what I can tell the committee that based on the circumstances and every time there was a deficiency, it was corrected to the satisfaction of the inspector, whoever was responsible for that deficiency list. So that's all I can say at this time, because as you said, you have the documentation that was sent over to PPD. fee waiver committee. So basically, I thought maybe it is because of the circumstances, it should have allowed, I guess, the owner, I guess, to waive that fee. So that's it. I conclude with this, and I request, I guess, from my point of view, I request the committee that please, if you consider the circumstances of that particular refusal or enforcing the fee, which is $182 for the inspector not to have the access. And I certainly hope explained all the circumstances, what the reason I am here in front of the committee. Thank you.
Thank you very much. There's questions for you, Councillor Edie.
Yeah.
Thanks for your presentation, sir. I'm looking for a little clarification. Are you the contractor who is doing the work, or?
I am the engineer. I am the applicant. I am the engineer. I've been engineer in the province all my life here.
Okay,
So,
all right, no, I just trying to confirm a couple of things. So you referred to owner, new owner. I'm getting a little confused about what owner. So what was the possession date on the sale of that property to
to be
the new
quite,
owner?
sorry about that, Mr. Ross. Yeah, go ahead, yeah.
I'm asking you the question. What was the possession date for the new owner?
To be quite honest with you, because although it was not my role to actually do the project management, which is construction, my role was to design the house.
Right.
And because of being an applicant, that's what I was getting the information from the city. Then I was relaying that information over to the owner. So
you-
I can't remember what was the.
That's okay, all right. So, because you're really saying it's the fault of the new owner that somebody wasn't there. So just to confirm, when you say the owner, that's who you're working for, the original owner who had to undertake the work and pull the permits to bring that house into conformance to the building code. Is that correct?
Yes, correct. You're right about that.
Oh,
part.
okay,
Yeah.
all right.
And then not only that, I want to actually further elaborate that because the house, I think, was sold one time, then the guy actually backed down. And then this was the second person, I guess, who bought the house, because of course I was corresponding with the owner, but it was up to the owner, I guess, what to do with the house, because my role was, I was trying to help him being an applicant, but my role was not actually to do the project management. But of course, whenever I was getting the information from the city, on the deficiency or other, I was relaying that information to the owner. Then owner was relaying that particular information over to the contractor so that all the bylaw, city bylaw and codes are in compliance. That's exactly what happened.
So you really, okay, so just to clarify, your expertise as engineer, you're the one who's coordinating that. You have no idea about how things were going down from the sale of one owner to the other, right? You have no information, but you're saying or making a statement that you want the fee waived because the new owner didn't stay there for the inspector to show up on that particular date.
It was not new owner. My understanding is from the old owner that the tenant who was supposed to be there, the new owner had a tenant in there. The tenant was supposed to be there so that he can let the inspector get into the place. That is exactly what I was told, because I was just doing, as I mentioned, like I just.
So would you agree, though, that it's the owner's responsibility to make sure that the door gets open for the inspectors to go in?
No, I definitely agree, because I deal with the city on regular basis, and I guess I 100%, you are correct what you are saying, but this is exactly under the circumstances. It should not happen. I guess if the house was not bought, maybe it was still the same owner, then probably it wouldn't have happened, because then it's just sort of misunderstanding, whatever you want to say, because the tenant, he said he will be there. This is the conversation with the previous owner. He said he will be there because I told him the inspector is going to go for inspection, and he knows, he made sure that he will be there, but when the inspector went there, he was not there. So basically, that's exactly happened in, under the circumstances in this particular case.
Yeah, now, I think this fee or whatever was paid by the original owner?
Yes,
You have
because-
to pay it, or
Yeah,
did
no,
you
no,
have-
you are correct what you're saying, because they said that because they wanted to make sure, I told them to close the permit, we have to make sure we comply with the city bylaw.
Okay.
And also the requirement, whatever, I guess was $182, it was paid. A lot of the time I pay, then I get it back from them. But this time, the owner decided to because of, they already actually sold that house, and the new owner wanted to make sure everything is closed and there's no work order from the city perspective. That was the reason.
Oh, income. Okay, thank you.
Thank you.
Any other questions, Councillor Wyatt?
It's okay now then?
Who pulled the permit? Who pulled the permit?
Permit, actually, I got the permit because I have the, I'm the applicant on that.
Okay, so you
house.
pulled the permit
Yes,
in question, and the permit in question is what is generating the outcome of this fee, correct?
yes.
So ultimately, if you pulled the permit and this fee is directly related to the permit, could it not also be argued that you were 100% responsible for ensuring access to that building, not the tenant, not the owner, but you as the permit, the name on the permit, pulling the permit, that you were responsible for getting access to that building?
No, I 100% agree with you.
If
but
you
you're-
agree with me,
Councillor
then...
Wyatt,
But
you
let
asked
me-
the question.
could I
We're
guess-
not getting argumentative. We're going to take it down a bit. And we're going to take it through the chair. But you've asked a few questions. He's going to respond, and then we'll go back to you. Go ahead.
I was going to say, because although I guess whatever the councillor you were saying is correct, but I think what happens when construction starts, I usually go to the site few times to make sure everything is in compliance with the code and bylaw. But I think the contractor was hired by the owner, and then I explained to him, because it's not my role to do the construction management, because I did exactly what I was supposed to do, get to the permit. Now, basically, based on all these drawings, and you must actually make sure the construction is done to the codes and bylaws. And then, of course, I was checking from time to time what exactly is done. And we also did the lot grading also. So anything to do with the engineering part, that's what I did, I guess.
So you were not the construction, you were not the actual construction manager? You were not the appointed contractor on site?
No, you are right about that part, because construction management usually, if I become responsible, any project manager or construction manager, they usually actually have a certain fee. Usually it varies from 10 to 12% of construction cost.
So you
but
were-
I was helping the owners.
So the extent of your involvement in the project was to generate the drawings?
Sorry about that, can you
The
repeat?
extent of your involvement on the project was to generate the engineering drawings?
Yes, yeah.
And that was the end of it, and as part of that, part of your contract was to pull the permits for them to be... Why were you pulling the permits and not the contractor?
Because I'm not a contractor, because the guy said to me, the owner said, because he knows the contractor from before. To be quite honest with you, it's not uncommon. There are a lot of time people say, okay, we have our own contractor or subcontractors, basically, because they don't want to pay. Also, because for construction management, that's what happens, because I think it becomes very difficult for me also, being a consultant for engineering perspective. I basically have to go to the site from time to time, make sure everything is done to the codes, and because I got to give the letter in the final. I guess that's basically, in this particular case, it's different because it's a residential, but for commercial, you need to make sure everything is done. Then you have to provide the certification letter over to the city to make sure everything is in compliance and to
It
the
seems odd to
codes.
me that the person doing the work is not the person pulling the permits. Why would you pull the permit if you're not overseeing the work?
No, but basically, as I said, like, because it was basically with the site visit were a few times, the site visit, but not the construction management. There are two different things we are
No, I
talking about.
know. Okay.
Any further questions?
No, I don't have any other questions.
Counselor Schreier?
Chair, just because this neighborhood's a tough neighborhood, and anyway.
Counselor Schreier has a question.
Yeah, a couple of things. Are we saying that there was a specific crime to the building that hindered proper communication or hindered the ability to follow through on the date due to a specific crime regarding the building?
Exactly. I guess I just mentioned that because of that's the information was provided by the owner to me, because when I think I got an email from the city, they're saying because of no access to the site or to the house, I guess then I asked them, then they said that's exactly what happened, because the guy was supposed to be there, who was a tenant of the new owner, and he never actually stayed there to wait for the inspector. That's exactly what happened. I'm telling you what the information was relayed by the owner to me.
Do we have a police report issue number to go along with this break in bureaucratic cooperation?
No, I don't have anything, basically, because I don't know if the owner ever actually report to the police or not. I don't know, to be quite honest with you. It was the owner who was dealing with the contractor and all the other stuff. But he did tell me that there was a break-in quite a few times there because of the location itself. And it's right actually in front of the school too on Selkirk, I guess. I am not sure what exactly happened. That's exactly what I was told by the owner.
Okay, and once again, the date for inspection, that date was sent to whom? Who received that date or who agreed to it? It's not all on you. I can ask the administration this as well. But if you do recall, given your role here,
No, I don't recall because they're dealing with a lot of contracts at a time because I thought maybe everything is closed now. So it's basically, to be quite honest with you, on the project, once the project is closed and the city closed the permit, then basically that goes under, I guess, under my files, the closed contract, closed permit, then basically if there was anything, it's a still outstanding an active project, then I will just make sure that I basically make sure I will keep it active unless it is actually completed. Permits are completed by the city, and everything is closed.
so you're saying that at the time that this finally agreed upon date for inspection took place, there was a change of ownership by this time, but you're saying it was a completed project by the time the inspection was meant to take place, and you considered a completed project, therefore the file was closed? Your file was closed?
Because I think,
That's what I thought I just heard.
say it again, sorry. Could you repeat that for me, please?
It seems like I just heard from you
Yes.
that because to you the file was closed, therefore you were not involved in any further communication with either the owner, the contractor, or the city, because the file was closed from your point of view?
No.
I really thought I heard that a minute ago.
No,
You
no,
closed-
I
closed
was
the file.
actually in contact with the previous owner on regular basis. Simple reason is because I was getting email from the city for the deficiencies, for the inspection, and also actually the owner, actually his son was actually making the arrangement also sometime. It becomes very difficult also. It's you only find out the inspection was scheduled once you actually communicate with the owner. But in this particular case, when I think the fee was assessed, I think it's $182, then I told them I was in regular contact with the owner, and then he said, okay, so if we can pay this fee, I said, you have to pay this fee, which is $182, and then once the inspection is done, everything is satisfactory to the inspector, then this permit will be closed. That's exactly what happened. The fee was paid, and I was told by the waiver committee from PPD that you have to pay first, and then you can go to the I guess, appeals committee, the city clerk office, That's exactly what happened. That's exactly what I did.
Could you explain to me again why you bothered to mention something about closed files? Trying to figure out what you meant by that.
Oh, that means once the project is done, then there's nothing is outstanding, then basically that's what I'm saying. I mean, a lot of the people, they want to make sure if they are selling the house, and not only that, the person who is going to buy the house, he or she want to know that there is no outstanding order from the city, or there is no issue or no deficiency before they buy the house. It is very common. It's not only in this particular case. I can give you hundreds of examples where sometimes people buy the house, but not knowing that there was some outstanding order from the city, or people have not taken a permit to develop the basement. I can give you a lot of examples about that, where I have to deal with that, because basically that is the reason I think some of these people, even real estate people, when they sell the house, they don't release this information, because it's only they find out when somebody goes there from the city, or somehow they found out there was some problem, or they find out, oh, no permit was taken and all that. I mean, then city is losing a lot of money. That's the number one, plus the stuff probably not done to the courts and all that. So basically, that is the reason I'm saying then that is what it is required, because if the people want to sell the house, they want to make sure that everything is done to the codes and city bylaw, so that all the permits are closed and no question asked from the new owner.
So did you work for both owners or just the first owner?
When you say both owners, what do you mean?
Well, I thought you said there was a change in ownership.
No, because I have nothing to do with the person who bought the house. No, basically it was done by the previous owner. I have nothing to do with that. No, I don't work for both owners. Okay. When I say both owners, but it's previous owner's son was also dealing with the city, I guess, because the owner itself had some communication issue. I guess that's the reason he was using his son to just communicate, I guess, with the city too. That's what I said, not the second owner.
Another question. Councillor Shire, are you done?
I think we've examined this upward, downward, each way.
Any further considerations then, Councillor Shire?
Look, if Councillor Wyatt thinks he's got his head around this one, then I look forward to his motions. There's a couple of things that I didn't understand regarding the first owner and the second owner, and the role of our applicant here, our appellant.
Well, have they been asked and answered,
No,
or do you want to pursue more questions? Because I'm in the chair, not Councillor Wyatt. So
What
is
is your
it
point?
still on you? I was going to move from you, if you were done, to Councillor Wyatt. He had his hand up. So it wasn't until I recognized him that he said he had a motion. We don't even know if we're timed for motions yet, because there could be other people speaking. So Councillor Schreier, take your time if
Sure.
you'd like, if
Well,
you have
thank
further
you.
questions. I'm just letting you know
So
that.
the role, Mr. Allock, today, you are representing the current owner and the current owner only, is that right?
No, I'm
you're
actually
not
representing the old owner, because they are the one who paid $182, because that time I was told by PPD committee, fee waiver committee, that you have to pay first before we can go for inspection. That's exactly what happened. I have nothing to do with the new owner, and I don't know who the new owner. In my opinion, I don't think it makes any difference to me who's the new owner, because the reason I'm here only to request the fee waiver that was actually denied by the PPD fee waiver committee. That is the only reason I'm here, and I guess hopefully hopefully I did my best to explain this, I guess, to the best of my knowledge, sorry, not knowledge, my recollection, memory. That's the reason I'm here in front of the committee.
All right. So you thought that the inspection date was none of your business after the building was sold and you are no longer involved in the building?
I don't think I said that, because I
No,
said,
well, you said you closed the file.
pardon me?
You said you closed the file.
No. When I said I closed the file, when the inspection was finalized, that is when I said that, because then there was no issue on the deficiency. The inspector went there, then the owner told me that inspection was done, they paid 182, and plus, I think at the same time, there was an email from the inspector that everything is done to the IKIL code and also city bylaw. That's what it is.
Okay, so there was an inspection took place.
Pardon me?
An inspection did take place,
Oh, inspection did take place, yeah.
and it was done after the original fee for the place not being conducive for inspection. It wasn't, no one was there to allow them in for the first inspection. There was a fee paid, there's a fee given, issued, a fee paid, and then an inspection finally did take place.
That is correct, yeah.
And when did the inspection take place with the new owners?
Oh, yeah, the new owner was there, yeah, but they made the arrangement, the old owner made the arrangement, make sure somebody is going to be there to let him go in there for the inspector.
Okay. And why would they were still involved with construction? There is still, with the new owner, there was still construction, but it was a different, you were not involved with the new owner? There was a different consultant engineer?
It's very simple reason, because that was outstanding. The deficiency or the inspector has to go in there, and then it was the responsibility of the owner, old owner. I explained earlier that to make sure everything is closed off from the city perspective, and there won't be any issue, I guess, with the new owner, although there was a new owner already there. That is the main reason they wanted to do it.
Yeah.
And that's not actually, it's unusual. That happens all the time, because basically, I just explained to you earlier, I can give you hundreds of examples where people, they do some work without permit, and then city finds out, then basically there is issue, because a lot of, whether it's a mechanical, electrical structure, whatever the case may be, building inspection too. So that's exactly what happens. That's why it's so critical to make sure, each contractor, the owner, have a proper building permit. Sometimes there's a development permit also. That's a new requirement. Basically, I don't want to go into details, because it's taking double the time now, because the requirement from the province of Manitoba that you have to have development permit if it's a new development before you get a building permit. It's at least you are looking at least minimum 2 months.
Yeah. Okay, thank you.
Yeah.
If there's no further questions, Councillor Wyatt.
I have one quick question.
Okay.
Molly, 856 Selkirk Avenue, tough neighborhood. I'm assuming you probably lost money on this project?
Sorry about that, I missed
I'm
that.
assuming you probably lost money on this project. It's a tough neighborhood.
Oh, yeah, because I
The
read,
guy,
are
the
you?
guy sold the property on you, and it's, anyway.
Yeah.
Yeah, all right, well,
Sorry, was that a
definitely
yes?
I definitely
didn't hear
have
an
my
answer, Councillor
sympathies
Wyatt.
for you, so thank you.
Councillor
I'm
Wyatt, I
prepared to-
didn't even
Thank
hear
you,
an answer.
appreciate it. Thanks for your time.
Did you answer the question? I didn't even hear an answer.
What exactly that question, sorry about
Right.
that?
Lost money on the project.
How much money?
I'm assuming you lost money on the project. It's a
Well,
tough neighborhood. It's a tough neighborhood to do business in.
No, I guess you are correct, because my understanding is, again, by talking to the owner, because I usually talk to him on regular basis, I did, and that is the reason he want to sell that house. He said he lost a lot of money. Very simple reason was because of the location, and plus the vandalism. Quite a few times he got to replace this,
Yeah.
windows and all that
Can't
stuff.
get
You are
fi-
correct what you're
You
saying.
can't get fire insurance in that neighborhood. It's hard to get insurance on a
To be
property.
quite honest with you, I don't know, because that's
yeah.
not my role for the
No, I do
insurance
know.
part, because
Anyway.
it was in owner's hand at that time.
All
Okay,
right.
thank you.
Thank you.
I'm
Sure.
prepared to move motion.
Okay, have a great day.
Everybody else is.
Before you do.
Can I go now?
Yes, you may.
Okay, thank
Hey,
you.
Councillor Wyatt?
I'll move that receipt of public
No,
representation.
Councillor Wyatt, like, I appreciate you're frustrated, but I still remain in the chair. I think it's really disrespectful that the way you're carrying out right now. Leah has a part, the clerk does have to check in with folks. You've been here for a long time, you know this. So I need you to recognize the chair because Leah has a part to play, and as we all do. So it isn't time for motions just quite yet. Leah, go ahead.
Just confirming that there's no one else in the gallery in support of the appeal or in opposition to the appeal, and no one with respect to the appeal for this address. Okay,
Now we're good for motions. Go ahead.
You want to move it, Ross?
Oh, you move it.
Or you want me to move it?
See what you do.
I'll move that receipt of public representations be concluded.
All those in favor? Any opposed?
I'm going to
That's carried
move that
unanimously.
the appeal be denied and the decision of the fee waiver committee of the Planning Property Development Department be confirmed.
All those in favor?
Aye. I move that the appeal
That's
hearing be
unanimous.
concluded.
Can I give some reasons for voting for it?
Yes, Counselor Edie, go ahead, and then I'll call the question on the final. Go ahead.
I'm voting for this. We had a discussion about a lot of aspects to the neighborhood and stuff. Actually, the higher you get up in the address on Selkirk Avenue, the better the neighborhood is, so don't just assume. But the crux of the matter was, there was nobody there to allow the inspector in. That's the whole point.
Yeah.
And I didn't hear any solid reasoning that there wasn't somebody there to meet the inspector to allow them to look at what was a properly completed project. So that's why I'm voting to deny the appeal.
Just on that point, Madam Chair, I think that's the issue. I mean, it could be he said, she said situation all the time where, you know, in this case, it was the tenant was supposed to open it, the owner, new owner, old owner. At the end of the day, one applicant is making the application for the permit, one applicant is responsible for letting the inspectors in to get access to the property. Either way, the access had to be granted. I hear, I'm sympathetic to the individual who made an application to appeal. However, if we were to start to waive based on that alone, we'd be waiving everything. So, thank you.
All right, I'll call the question. All those in favor?
Aye.
Carried unanimously. And then Counselor Wyatt, you're moving to close out the hearing. So moved by Counselor Wyatt.
Yes, Madam Chair. I move
All
to
those
close.
in favor?
Aye.
Carried unanimously.
Can we
We'll
take a
move on.
health break for 5 minutes?
Just after we close the hearing, go ahead.
please note that the committee has made a final decision on this matter, which is not subject to further appeal.
We'll be taking a 5-minute health break, and then we'll move on to item number 4. Yeah, no problem. Yeah. All right, we're back at the Standing Policy Committee on Property and Development, the appeals for P&D with 240 Chestnut Street, which is item number 4 on our agenda. We'll hear a summary from the administration.
All right, good morning. In March of 2023, the applicant submitted an application for development permit to reestablish a vacant multifamily dwelling at 240 Chestnut. Speak up a little bit. Sure. All right, let me know if you can. It had previously been configured as a 15-unit dwelling, and a determination was made by the Public Service to grant non-conforming rights for the density and the parking to enable the reestablishment of this dwelling through development permit. That permit was issued in July of 2023. In December of 2023, the applicant submitted for a building permit, and the application was refused as there was some modification to the plans. This required a re-review of the development permit. Upon re-review, it was observed there was some changing to the non-conforming rear yard, increasing the degree of nonconformity. It was
Sorry,
unclear.
can you say that again? I missed it entirely.
Yeah, so there was some change between the initial building permit
Yep,
between the initial development permit and building permit, it required re-review. Upon re-review, we noticed that there was changes to the rear yard setback.
Yeah.
And so, as a result, it was unclear how the Public Service's previous interpretation applied to that non-conforming right of the rear yard. After some discussion, we did honor the non-conforming right for the rear yard and issued the permit in March of 2024. So the applicant's argument is that this inconsistency in application of non-conforming right on the re-review caused an unnecessary delay. They state that their carrying costs were approximately $5,000 a month, and that the two-month delay resulted in a cost impact of $10,000. As a result, they state the building permit fee of $8,506 should be waived to offset this loss. And our position, non-conforming rights are typically valid for a year when a use is unoccupied. A generous interpretation was taken in regards to non-conforming right to enable an ambitious and commendable housing rehabilitation project. This position resulted in development applications not being required. Changing of the plans between development permit and building permit did result in some confusion and inconsistency on the behalf of the Public Service. In the end, we did honor all non-conforming rights. We do feel that granting a fee waiver for a correctly applied building permit is not a reasonable accommodation, given that the development permit was the cause of the delay. Reimbursing building permit fees due to delay would set a precedent. And lastly, we do feel that fees collected under building permit represented a manner of cost recovery and honored work performed related to the building permit. So as a result, we recommended that the fee for the building permit be upheld.
Questions, Councillor Wyatt?
And that fee is $8,506.66.
Correct.
And his argument is that this created a needless delay that cost him $5,000.
A month. 2-month delay, $10,000 is their stated
Based
care.
on the fact that the contract was already pulled and the clock was ticking on his contract?
I don't know the details. You'd have to ask the applicant.
Okay.
So, it is a bit of a, it's a bit of a circle insofar as you start with a development permit, the department rethinks that development permit, and you end up not requiring it. Now you see what is to be built, so the question is, what changed on that non-conforming rear yard? And if you're making the argument that a year is generous, was generously applied, then can you fill me in on what dates you consider to be generous when you have a year?
Okay. I'll start with the first bit.
Some of that is before me, I recognize.
Yeah, the first bit was when we looked at the interpretation made, the original non-conforming right interpretation was, I believe, late 2022. It was clear on the density and the parking. When the
Say that again, I just couldn't hear you.
the initial interpretation
Yeah.
on non-conforming right, it was clear on density, so saying the 15 units.
Yeah,
And the parking supply,
Okay.
zero. That said, when the applicant had to come back for re-review, because they did some modifications to their plan at building permit, the rear of the building, they were doing an addition, building up above the existing dwelling at a very reduced rear yard. And so where we had difficulty on the re-review was that covered under non-conforming right? As far as statement around a generous interpretation, the bylaw and the charter generally say that if a use is unoccupied for a year, it loses that non-conforming right. There is some flexibility on that, and to be clear, I think the project is of value. It's commendable to rehabilitate an older building like this.
Sure. So I guess my question more to the point is, how long, like, when you have a year, it typically is, you have a year because you're kosher, selon the department, so like according to the department. But in this case, they apply, how much time did we eat into that, reassessing our stuff? So if we eat in 6 months, which I think Mr. Montaigne is going to come up here and say, as he says in his letter, then is that 12 months plus that 6 months when he doesn't have that DP?
For clarification, the year was before they've applied, right? That building sitting vacant for more than a year is what puts the nonconformity at risk.
Sure.
So by granting nonconformity, even though it had been vacant for longer, it prevents the need for development application to reestablish the use. So that's kind of one separate thing. As far as timelines, ideally we would have been quicker. There's no debating that. As far as how long it took to review and issue permits.
So it's accurate then to say there's a non-conforming right. In the intervening time, it's more than a year. That intervening time goes back and forth on the non-conforming right, but then ends up with the non-conforming right in place at the end of the day.
Yeah.
Okay. And then with respect to the carrying costs, it is a precedent setting, I agree, and typically that's why we're here. Okay. Any further questions? Counselor, all three of you have questions? Okay. Okay, we'll reverse engineer it then. Counselor Schreier, then Counselor Edie, then Counselor Wyatt.
I wouldn't consider that reverse engineering, but anyway, Councillor Rollins, here we go. Thank you, Chair Rollins. And regarding, Councillor Rollins was talking about the year, and talking about what dates within the year. How long is this year? Is this 365 days? How long is this year we're talking about?
Sorry, are you asking how long we?
Yeah, this year of which we speak, of which Councillor Rollins was asking questions. Was that
In the context of considering how long is that year for a non-conforming right, yes, it would be a full 365 days.
Okay. And then this 2-month delay. We're talking about a 2-month delay, which is why they're asking that this be waived, given their costs over these 2 months. And where does this 2-month delay, where does this fit into this year?
Yeah, the 2-month delay comes in the building permit that they applied for. Just for clarification, applicants need a development permit first, and then the building permit. So they came in for their building permit December of 2023, and between when we issued, which was March 3rd, I think, and December, that was the 2-month delay. And that was where processing time, as well as trying to sort out how we could treat this under non-conforming right, that's where the 2-month delay came from.
Was this 2-month delay, is this unusual? But they call it a delay. One could say it's bureaucracy. I got patience for the bureaucracy. I understand why people are frustrated by that, but I understand why we have these things. And so do they, and in general. So, what can you tell us about that?
Yeah. I think, this is an assumption, but I think that the frustration comes from the applicant in the fact that they had a development permit issued. They came in for their building permit, and I do believe they acknowledged they made some changes to their plans. So the two permits have to match. So a re-review was required, but I think their frustration stems from the fact that it felt as though we were re-examining their non-conforming right.
That you were what, sorry?
That we were revisiting their non-conforming right. And that's why they're saying, well, why are we talking about this? We dealt with this already. I think that's the logic behind.
And your argument to that is?
that there were some changes to the plans that when we looked at them, right, this played out over a number of years, but when we looked at them in December of 2023, seeing that there was building mass going up above the existing building at the rear yard, when you modify a non-conforming right, typically you're kind of opening that can of worms, if you will. So we were, in our attempt to be diligent, we were looking at that. And we were unclear as to how far the previous non-conforming right went.
Okay. Now, they do say that, it does say in your exhibit that the applicant has acknowledged that the building permit fees were correctly applied.
Yeah.
Could you tell us about that?
And that's something I hope folks understand here, that this is a bit of a unique request. In effect, I don't think there's any dispute that the building permit was needed and it was done correctly and administered correctly. The argument is that zoning delayed their project. And in an effort to recoup an amount, a carrying cost amount, the building permit fee is close to that amount. So it's tough to say because of a delay, we should just waive a properly administered permit fee.
Okay, but you're saying in this case it's unusual because the zoning process hindered, set back the timeline of their development. Isn't that par for the course in the world for zoning to take time? I mean, what was the expectation? What is normal?
It can be. I mean, unfortunately, permits can take longer than people like, and that does have business implications. You know, in this case, there was added complexity of non-conforming right, change to plans, a need to revisit the development permit.
Okay. Thank you.
Councillor Edie and then Councillor Wyatt.
What I want to help you to help me understand is, so there were some design changes after they filed their building permit, right?
After their initial development permit that was issued in July of 2023,
Okay.
and their building permit in December of 2023.
So they did a modification at what point in that?
After the development permit, prior to the building.
Prior
so
to
the
the building.
building permit showed the changes.
Right, okay, now, okay. So development permit is filed, it's gone through, there's an acknowledgement that there's some non-conforming rights. Did the modifications proposed in the building permit egregiously change the, that right?
I wouldn't say egregiously.
Or was it still the same?
No, and perhaps the applicant could speak with more detail, but my recollection is that basically the building mass at the back of the building was getting taller at that reduced yard. I believe it was 1 story when they started. They were doing an addition at the back that was basically going higher at the same setback, but the setback was,
Right.
again, forgive me, but I think it was about 4 feet.
So that difference, so the non-conforming right was increased by 4 feet?
Not necessarily. I think they were keeping in line with that, but they were building the building higher, right? They were going up.
Okay.
Yeah.
So the, again, the non-conforming right didn't change. It was still the same.
That's not trying to be
Well, no, it, like, either it was changed or it remained the same as it would have been
Yeah.
at the development application.
if generally, if you touch a building structure in a reduced yard that's under non-conforming right, we re-review it, generally.
Okay.
So
the mass change, so
Yeah.
that did change, make the non-conforming right a little bit more non-conforming.
yes,
Okay, but
one could say that.
what kind of percentage were we talking about? Like,
I couldn't give you a percentage.
Pardon me?
I don't know. I couldn't give you a number.
So you don't use that as a basis of deciding this fee waiver or whatever they're asking?
No.
No.
Anyway.
No.
Okay.
No.
Counselor Wyatt?
Yes, you mentioned, Dylan, that we were unclear of how far the unconforming rights went.
Yeah.
Why?
Again, because this played out over a few years, I do have to speculate a little bit. But when I look back on the interpretation that we had, it acknowledged density and parking. I don't know if it could contemplate the design of the building at that time. So over time, you know, this gets to the point of a permit where it's very detailed. All of that information about how they're going to do addition and modification comes, and from there, you know, we look at it. So I think we were, when I say unclear, I think we acknowledged there was documentation about density and parking, but we didn't have a clear understanding if the rear yard was covered under that.
In his letter, he states in the last sentence of the second last paragraph, it appears that the director of zoning who granted our development permit in the first place has moved to another job, and his decision was not attached to our file somehow. Is that accurate? That there was maybe a bit of a discrepancy within the file itself in terms of the previous decision and the supporting reasons?
There could be some of that.
So there is a bit of potential that there was a lack of, how could I say, a lack of institutional or decision-making, previous decision-making supporting arguments for the previous decision that were not substantiated in the file that would have been useful to you, so that maybe the delay wouldn't have been necessary.
There's an element, and in fairness to previous folks, there was documentation, like I said, about density and about parking. But the yard issue came up.
Right.
And that was what we struggled with.
This is the non-conforming rights?
Yes.
Yeah.
Sorry,
So
may I
there's a-
piggyback on that question? Just a yes
Yeah.
or no. We have before us that there was documents that weren't attached to the file that perhaps the applicant had, that the department did not. To your knowledge, is that correct?
We had some documentation about non-conforming right. But it didn't,
It was of a
Wasn't
certain
clear on-
scope, as you've described.
on all elements, it wasn't clear to us at the time.
Do you think another document then existed that was clearer to the applicant?
I don't know.
Okay.
I don't know. Without seeing it, I don't know.
Okay, sorry, Councillor Wyatt, I interrupted.
Yeah, no, that kind of speaks to, thank you, Madam Chair, that speaks to the question I had, which is the discrepancy that he's pointing out, I guess, is the frustration by, picking up in his letter, is that he had a paper trail that maybe the city didn't have or something, I don't know. So, yeah, okay. I'm looking forward to hearing the applicant.
With respect to this project, you mentioned about the precedent-setting nature. We have waiving of permit fees for not-for-profit housing, for instance. That's a policy that council can take advantage of. But we don't have one that sort of swaps a fee structure that was rightly applied to consider carrying costs. Would it fit under not-for-profit housing?
I don't know. I don't know if it's non-for-profit. That could be a question for the applicant.
Yeah.
I think, again, our primary concern when we state precedent is just getting to a point, not saying it will happen, but getting to a point where delay could
Yeah.
result in consideration of waiving permit. Because, you know, we strive to be expedient, but I'm not going to lie to you, delays happen.
Yeah, no, it's, yeah, I agree. It's a precedent. Yeah, there's a lot to think here. Okay, well, if we don't have any further questions, we'll move on to likely the appellant.
So the appellant, Tom Montoyn, is here in person today.
Mr. Montaigne, if you'll join us at the podium down here, you'll have 10 minutes with committee.
Good morning. Can you hear me?
Ken?
So I'm Tom Montaigne. I'm an architect. I've been in practice here for 31 years. I deal with PP&D and zoning almost every day of my working life. Generally, I'm supportive of the work. It's a complicated business that we're in. This particular project is a bit unique because we're the owners of the building, we're the developers, we also own the construction company that's doing the work. So partly because of that, I am fully aware of every aspect of this project. It's completely non-conforming building. It's in kind of on the edge of Wolseley. It's one of the few derelict buildings. It was boarded up and derelict for at least 5 years. I didn't come here today to complain about the boarded up building and derelict department of the city, but they're also,
Different day.
because we're the owners, the new owners, and we're not responsible, I don't think, for 5 years of dereliction, but we're still dealing with that as well. But this particular project, we entered into it knowing it would be a challenge. As I said in my letter, we were very pleased that the city recognized the situation and granted us the right to redevelop this property. And the one thing I would, there's a bit of a gap between when we got our development permit, which, by the way, was kind of a new process. We're already a bit more familiar with it. And then when we applied for our building permit, it was a bit of a gap. And, due to the requirements of the project and this is where I think I disagree with what the person from the department just said, because I believe in our original set of drawings for the development permit, it showed a second floor all the way to the, end of the building. And I say this because we're proposing, and fact is it's well under construction now, so we're building a new exit stair on the back of the building, which was also part of the non-conforming part of the project. So the physical configuration of the project has really not changed. There was a brief period where, we were allowed 12 units, and for various reasons, and this was part of the delay, we thought we could maybe get 13 units in there. And so then, when we submitted that did cause a bit of a problem with zoning, because that really was changing the non-conforming. And so we revised it back to be 12 units. It is possible that when we completed the construction drawings that maybe the projection at the back of the building was slightly different, but it would have been maybe a couple inches. It really hasn't changed, in my opinion. And, I did learn a bit more about the actual process today, listening to the presentation. So the idea that there was enough difference between drawing sets that a re-evaluation may have been required. We weren't aware of that. Nobody told us that. Again, this development permit, building permit thing is a relatively new. But the reality is that we were, we submitted for our building permit, and then talking to the zoning officer, which was a different zoning officer than the person that did the development permit. And she said, well, your project is non-conforming and now you need variances. And that, was something that we obviously had worked hard to avoid because, nobody was kidding anybody. This was a completely non-conforming building. There was no way to make it conform to the current zoning bylaw. And it's, I guess that's why I feel like this is a legitimate complaint because, zoning brought up variances. Variances should have been off the table, in my opinion. So, I guess that's why, I meant to mention that even though I deal with PP&D a lot, I have never complained about building permits or fees before. So this is the first and maybe the last time that I'll do that. Anyways, I feel like my letter was fairly clear. If you have questions, I'd be happy to try to answer them.
I do have some questions, and perhaps if I ask them, it'll whet the appetite of my committee for more. Typically, what we hear in appeal is something on the basis of an argument with respect to the actual permit. But you're bringing something that turns on the amount of time that it took to render a decision that cost you money versus something that wasn't properly applied to you. So that's a bit of a difference for the committee. Can you talk about the timing? It would have taken time, for instance, and talk about how many people, handled the file that you saw and changes of opinion between, for instance, the person that said, like the intervening time between, well, now you need variances, and what interventions you were doing at the time with the department, if any.
I'm sorry, what was the
Were you
the last
phoning the
things?
department? Like, I'll ask the first question first, which is, can you take me through the dates where from purchase of the building to your application, and then how long you were stuck between the differences between the development permit part 1, going for your building permit with a development permit in hand, and then development permit part 2 and 3, which is when they sort of pulled it back. Can you talk about that intervening time? Mm-hmm. And what was happening for you? Because you had a development permit.
Yes. And to be clear, I'm not complaining about how long it took to get a development permit. It took 6 months. Again, it's sort of new. It's hard to have a perspective on how long that should take. I think it's a challenging project because it's unusual. But in my business, that's kind of the projects we do. We work in the inner city. We do infill projects. Infill projects basically almost always require, negotiation on zoning regulations. And this project was, I would say, an extreme example of that because it's a huge amount of building on a fairly small residential lot. And that's the existing condition. And we actually made it bigger because we needed to accommodate an exit stair.
You're in a sense complaining, if it's fair, that the original development permit didn't stick. It wasn't something that the department had fidelity to. Is that fair to characterize your complaint? It's in your letter, I think.
Well, I see.
I appreciate that you're underscoring your very good relationship with the department and how long of a tenure you've had in terms of experience. I'm also reading your letter, and I'm seeing an argument that the department had no fidelity to the original development permit.
Well, that was my interpretation. I mean, I heard a little bit more just now. But my contention is that the design physically has not changed in a substantial way.
What did you hear just now
Well,
that was different than when you're appealed, if you?
well, you see, the second zoning officer, when we applied for the building permit, said, you know, your project's non-conforming and you need variances, which to me is like a backtrack.
Right.
Because the whole point of a development permit is that you negotiate, you go through all the city departments, and you get approval. Then you go to your building permit, which is another, you know, it's a different thing. I think it's probably a good process. It's probably going to be good in the long run. It's you know, except that then the idea that nothing can change, like, I think we should be willing to accept that there could be some slight modifications, because as you do construction drawings, you get your consultants involved, and things that you draw might have to change slightly just because of other requirements. So if that were to happen, you know, and that requires a re-review, you know, I wouldn't see that as unreasonable. However, what I'm saying in this case is I don't believe we changed the physical shape of the building. So that's where I guess I disagree. The other part of it, though, is that, you know, you don't get a lot of feedback generally from zoning when you're in this process. So all I got was you need variances. So I didn't know that there was kind of this reinterpretation or kind of a concern that something had fundamentally changed. I think we could have talked that through potentially. Maybe that would have made it quicker.
Is it fair to say you did talk it through, though, because you do end up with the reestablishment, like you did in the original development permit, of the non-conforming rights? You
Yeah.
don't apply for variances.
Yes, we did.
So how?
But it took
what-
2 months to get that.
Took 2
And that's where I'm saying that I feel like that's egregious.
And what did you do in those 2 months? What does that look like for you? What are you doing?
Well, we're, you know, panicking
Okay,
because, you know, and I mean, in this case, I am the developer and the owner.
yeah,
Normally, I'm working for somebody that's a developer and the owner, and they're panicking and freaking out. In this case, it was me. So, you know, projects like this are, you know, they're not like super viable. Like it's a kind of a borderline project to begin with. So, and you know, the amount of inflation in construction costs, that's not your problem. But, you know, it's really put a lot of pressure on this project.
Cheryl or Councilor
So-
Scheer? Yeah, no, construction inflation is our problem too.
Thank you,
Yeah.
Cheryl.
Sherry. Okay, and then you say the 2-month delay cost the project roughly $10,000, and these costs were completely unnecessary and unavoidable, which turns on your argument that you had a viable development permit. It was then returned to.
Yes.
Okay, those are my questions. Councillor Wyatt?
Thank you, Madam Chair. Your contention, if you're the developer and the contractor as well, what's the rationale in terms of your $5,000 loss a month?
Well, that is, I mean, we bought the building,
Yeah.
so we're paying a mortgage every
Okay.
month, which
Right.
was almost just under $4,000. You have vacant building insurance, which is extremely expensive. You know, surprisingly expensive. Insurers don't like vacant buildings, turns out. And there was a couple other costs. Like, I could substantiate this, like I didn't put everything in this letter, but it's about $5,000 a month, and, you know.
This is even though you control the construction company.
Well, this is
These
way
are
before
These are costs
construction.
outside of your control.
Yeah, well, it's the cost that the developer has because, you know, you bought the building. Because, you know, you can't really go for a development permit unless you own the building.
Right, and the development permit, correct me if I'm wrong, you say, I got the impression that's kind of a new world to you, the development permit versus just a building permit. It's largely, that's basically kicking in because of the fact that it's a vacant and derelict building, correct?
No, all projects need development permits.
So then why was that new to you?
Well, because it only came in the fall of 2022.
Yeah.
Oh, I see.
That's where you split.
So I think this might have been the first one
I
that we
see.
did.
And then you said you changed it, the project by a few inches, and that in that you believe that was not much. However, that's probably what might have generated the issue of the requirement for now a variance. Is that fair to say?
Well, I would have to do a forensic examination of the develop. I don't believe there was much change, if any.
But other than the fact there was a few inches changes related to trying to go from 12 to 13 units.
Well, that was I'll admit, a dumb idea on our part, and we went back and we got rid of it.
Okay.
So we went back to the original proposal.
So one of the two probably had something to do with the fact that there was a delay related to this.
Well, I see.
Why?
The 2 months was after we had resubmitted our drawings with the original density.
Okay?
I guess that's why I believe we had kind of cleared all those potential problems.
Okay?
And I'm not willing to agree that there was change between our development permit drawings and our building permit drawings.
Okay.
I would have to
Well,
examine that.
so where did the change come in terms of trying to go from 12 to 13 and the few inches? Where did that happen?
Well, that happened in our first building permit application.
Oh, what, the first?
Which, then we went, okay, this is crazy. We redid it, and which
Okay.
meant redoing the
So
drawings.
it's not related to the delay that occurred later?
In my opinion, it is not. Perhaps I shouldn't have brought that up, sorry. It's just
All right.
it's a complicated project.
Okay, all right. And we heard from the administration, they may recognize that maybe there is some documentation that was not in their file related to what you said at the end of your second last paragraph. It appears the director of zoning who granted our development permit in the first place had moved to another position, and his or her decision was not attached to the file somehow. And they kind of recognize that there may be a bit of truth in that. Do you want to
Well,
comment on that?
I don't know. It's just that that's the way it felt because,
Why did you speculate on that then?
well, because when we were told we needed variances, of course, I called the zoning officer and said that I don't understand why this would be the case. We have a development permit.
Okay.
Why are you going backwards? You know, and to be honest, you know, she couldn't really tell me. And so then, but, you know, 2 months later, we find out that the person who was head of zoning had confirmed that our non-conforming rights had been, you know, granted and that this project should be allowed.
So the
Now,
issue
I
was-
didn't know all the machinations that
Oh,
happened
right.
behind.
You don't know what you don't know. So it really was over the uncertainty of the non-conforming rights.
I guess so. I don't know if that was ever completely made clear to us, to be honest.
Okay. I don't have any other questions, Madam Chair.
Okay, Councillor Schreier has some questions, and so does Councillor Eady.
At one point, you mentioned something about that the city brought up variances that should be off the table.
Yeah, well, that's what I'm saying. You know,
And they should be off the table. Why should they be off the table?
because you have a development permit. Because you shouldn't, like, if you need a variance,
That's that
the
time.
way I understand, the way it's supposed to work is we're going to do that at the development permit stage. And we had a development permit. That's why I feel like it's kind of reneging.
Okay, and this is not related therefore to that phase during which you were looking to make changes, like add a suite? That had nothing to do with that those variances that you said should be off the table?
Well, I mean, the reality is your development permit drawings is what we would call schematic design drawings. I mean, they show the outline of the building, they show how it sits on the site, they show how big it is. Like, I'm pretty sure we submitted elevations which showed the full extent of what we were proposing. But then by the time you get your working drawings done, you have a lot more information on the drawings, right? So the drawings are more complete. Now, my contention is we didn't change the exterior configuration.
Sorry, your contention is that, what was the last sentence?
Didn't
I
change.
said we did not change the exterior configuration, which is the part that is non-conforming.
So the number of suites wouldn't have changed the placements of the windows?
Well, I mean, by the time we got to what we're talking about now, we were in compliance with the original agreement.
Thank you.
Councillor Edie.
Well, I have one question. I'm sympathetic to your appeal here, but you purchased the property on a mortgage. Is it a construction period loan or is it a long-term mortgage?
Well, the original mortgage is short-term because essentially the current mortgage is a construction loan with a different lender.
Right.
So
Okay.
yeah.
I just wanted clarification. You're saying the mortgage is 2 extra months of cost, but that's because you have a construction period loan, right? So, okay. So the project is moving ahead with 12 units now, right?
Yes.
Okay. All right, that's all I wanted to confirm.
Any questions, any further questions? I don't think my questions are for you. I think I have a follow-up for the admin. But thanks for coming today. I don't have a further question for you, and I don't see any further questions, but thank you for coming.
Okay. I mean, I will say that I appreciate that I'm conflating, something that, but, there's really, I couldn't see any other way to complain, so this is kind of like a complaint.
Fair. Okay, thank you. Okay.
Just confirming that no one else in the gallery is here in support of the appeal or in opposition to the appeal or with respect to the appeal? No? Okay.
Yeah, go ahead.
Thank you, Madam Chair. I'll move that receipt of public representation be concluded.
All those in favor?
Aye.
That's
I'll
carried
move that
unanimously.
the appeal be allowed in part and that 50% of the said fee of $8,506.66 be refunded or waived, as the case may be, for a total of $4,253.33. And so therefore that the decision be partly canceled, I guess. That would be the decision, but other than the fact that I would make my supporting argument, it sounds like there's a bit of back and forth here, with lack of communication, lack of maybe information in the file that would have led to a quicker decision being rendered, as well as maybe preventing this from having to be revised in the first place. By the sounds of it, I give, in light of the fact that this, the applicant was both the architect, not both, architect, the contractor and the builder, in this case, all three levels, knew the file quite well, that it was early in the changeover of the city's processes from requiring a development permit front. All of these things are kind of coming together where I think part of the responsibility is on the city, but also part on the owner. Therefore, I'm not prepared to waive the entire fee, only 50%. And I think it's fair based on what we've heard today to try to play the role of Solomon. So,
Any further discussion? Councilor Edie?
I'm going to be supporting this motion, and my main, while we have an appellant complaining, I mean, now it's clear you have a development permit. If you decide to add more density, like, you're going to cause a problem. I think this is reflective of the learning process for both our public service and for developers. And my biggest concern too is that we have to be concerned about infill and dealing with homes, because it is really difficult when you're dealing with these properties. I can think of many in North Point Douglas that will become very difficult if you want to maintain the historical flavor of a neighborhood and stuff. So I'll leave it at that, but I'll be supporting the motion.
Councilor Schreier, any comments? Nope. If I may, I'm going to put a few comments in the record. First of all, this isn't the first time that I've heard, a story about someone getting caught in a development permit and then getting to building stage with a development permit in hand, only to be told that there needs to be a reexamination of the development permit. And while I really appreciate the motion and I want to be supportive, I'm going to occupy the space that I think that we have to revert to a really different policy and an examination of, how we've broken apart the development permit and the building permit, and how we've in fact staffed our public service with an implicit sort of agreement with council. I don't believe it was explicit, but I do believe that it is now, and it has been for the last year, that used sort of an administrative tool that people have to wrap themselves around that isn't, that sometimes isn't really the agreement that we state transparently, that first there's a development permit, then there's a building permit. Unfortunately, there sometimes is a renegotiation and human resource issues that lead to delays. I do think it's, really interesting. I do think that there should be a mechanism that we look at these fees, but right now we don't really have one. So I will be opposed. I'm just going to occupy the space that there's more policy work to do to support this discussion, and for those reasons, I'm out. But I'll call the question. All those in favor?
aye.
That was carried. I'll be marked in opposition. And if you want to close the hearing, Councillor Wyatt, with a motion.
So I'll move that the hearing with respect to this application be concluded.
All those in favor?
Aye.
Carried unanimously.
Please note that the committee has made a final decision on this matter, which is not subject to further appeal.
Do you want a health break? Okay, can it still be 5 minutes? And then we'll go on to number 6, which is the 14 Riverside Drive, and then we'll move into the last hearing. So 5-minute health break. Okay, welcome back to the Standing Policy Committee on Property and Development regular meeting for appeals. We're moving into item number 5 of our agenda, which, if you're following along, the amended the agenda earlier, so it's item number 6, the vacant building bylaw appeal for 14 Riverside Drive. We'll call you up in a second. Like I said, you can sit on the bench that's back there, and we'll call you up. First, we'll do a summary from the administration. That's fine, too. You can sit there.
Good afternoon, Madam Chair, councillors. My name's Martin. I'm the Operations Coordinator with Licensing and Bylaw Enforcement. I'm joined today by Corey Burgess, who's the Bylaw Enforcement Coordinator for vacant buildings. I will provide the overview, and Corey was here to provide any specific details with regards to communication with the owner or any representatives. The vacant building bylaw was established to regulate the conditions of vacant buildings and discourage boarding. As the committee is aware, this is done for the safety of our first responders and the community safety and overall well-being. Most service requests that licensing and bylaw enforcement receives are complaint-based in response to community concerns about vacant buildings via 311 and/or referrals from other agencies such as the Winnipeg Fire Paramedic Service, that sort of stuff. Our overview of our enforcement process: when a building is determined to be vacant, an information package is sent to the owner identified by who is identified in the City of Winnipeg Assessment and Taxation. This information package informs the owner that the building is deemed vacant and subject to the vacant building bylaw. A brochure on the vacant building bylaw is also, and all the associated fees, and the contact information of the officer and of our office. Following Section 15, subsection 2 of the vacant building bylaw, the bylaw enforcement officers are to inspect vacant buildings regularly. At least once per year, officers will inspect the interior and exterior of a vacant building. The inspection identifies that minimum property standards are being maintained as Schedule A of the vacant building bylaw outlines. Once a building has been deemed vacant, officers will take up to 90 days to get in contact with the owner. Officers will take this time to attempt to establish how long the building has been vacant, how long it will remain vacant, and the current conditions of the property and how it is being maintained. After this time, officers will schedule an inspection of the property and the interior and exterior of the building. Officers who attend vacant building inspections assess conditions for bylaw violations and issue compliance orders. It's important to note that all notifications of orders are sent in writing to the address provided by the owner to the City of Winnipeg Assessment and Taxation Department and are served to the property owner via registered mail, following the Winnipeg Charter and the bylaw. Owners are responsible for retrieving their mail and complying with all orders. However, orders are deemed served after 3 days. All compliance orders, including the officer's name, a direct phone number, and an email address, are provided. The order also has contact information for our general line for licensing and bylaw enforcement services. This information is provided to facilitate communication directly with the owner and the bylaw enforcement officer. Officers will attend the property after the compliance date and confirm that the conditions outlined are corrected and that the property complies with the bylaw. When conditions are not compliant, the officer will begin the enforcement process, which could include possible fines, fees, and in some cases, remediation. The bylaw intends to ensure owners maintain their property to avoid unnecessary risks to the first responders and to the community. So the details of this, we received the complaint on June 22nd, 2024. As a result of the complaint, it was determined that the owner of this property has owned the property since June 2019. We did an on-site investigation July 5th, 2024, and it was declared vacant by the officer July 17th, 2024. The information package was mailed out to the address received on a tax that same day, July 17, 2024. As a result of our inspection, a Schedule A order was issued and identified deficiencies on that property. 2 orders were issued to that subsequent inspection in December of 2024. One was for vacant building security, which means it was open and accessible. And the other one was for the Schedule A conducted on that, which we are here to hear the appeal. As it stands, the outstanding invoice was due January 9th, 2024 for that inspection, and that is still outstanding and has not yet been paid.
Okay, any questions at this juncture? Yes, Councillor Wyatt.
According to the email we received from the appellant, they're saying, I get the impression from reading it, that their intent is to do a demolition of the property. Because they're saying here the house was far from livable or repairable when it was purchased. This fact was made very clear by the realtor. As such, it was sold, bought with the intention of a complete rebuild. To conduct the above listed repairs, given the overall state of structure, does not seem reasonable. What's your understanding in terms of their intent for this property, since you're saying this owner owned it since 2019?
So the facts are correct. Our ownership since 2019. So the vacant building bylaw identifies deficiencies.
Right.
So the deficiencies are to make sure the property owner is aware of the risk of what's going on with that vacant building. So, communication, whether it's with the property owner, the intent of the property owner, from our perspective, isn't really relevant because we hear, well, we bought it for this, or we want to do this with it, or this, that, and the other thing. We enforce the vacant building bylaw. The building is vacant. We determined it was vacant in July of 2024. So that's almost 5 years after our understanding of when it was purchased. So again, we are complaint-based. We got the complaint, we investigated, we determined that it was vacant, and we issued orders per that fact.
So my next question is, in light of the fact that they've had it for 5 years prior to your involvement, was to your point, did the department receive any sort of application for the purpose of demolition / redevelopment of the site?
So our department does not handle those applications. That would be with property planning and development.
I know, but it's still the city, right?
Yep.
So are we aware of anything like that? Okay. I hope departments or divisions are talking to each other.
Yes, I do have that information. As of 2019, and Kelly can confirm, there was an application for a demo.
There was?
Yeah.
When was the application made?
Councillor, if I may, it's our understanding that there was an inquiry made about demolition in September of 2019. It did not proceed. And again, as Martin said, I would defer to PP&D.
Who's speaking?
So, sorry, Councillor Wyatt, he was introduced, this is Mr. Burgess.
Yeah.
He was introduced by Leah Cowan earlier in the meeting. Leah Cowan will reintroduce him if you did not hear. But that you can take through the chair. Have you not met him? He works for P&D.
Which division?
So Corey Burgess works for Community Services. He's the field operations coordinator in charge of vacant buildings. And he can provide specifics about communication with regards to the appellant or any other representative of the property owner.
Kelly, did we receive any kind of demolition application?
No applications on file that I can see going back to well before 2018.
And there was no application submitted with a redevelopment plan?
No, sir.
And I guess my question is, what are the fees outstanding now in terms of this vacant and derelict building permit?
So Corey can provide the specifics, but the outstanding fee and the amount Corey will provide is for the inspection of the vacant building associated with the
How much is
inspection.
that?
Corey?
$1,685.
And my understanding is your fees escalate over a period of time, correct?
That is correct.
And so when
Fees
is,
will escalate yearly, and after 3 years, it will also trigger an empty building fee of 2% of assessed property value.
so yearly, or I thought it was every 6 months?
It's after,
The inspection fees are annual, and the empty building fee is an annual.
And what does it go to next?
If the building remains non-compliant, it would increase by $1,000 for next year's inspection.
And when would that be?
Roughly December 2025.
So it would go to 2,608, is that right? What would be the new fee?
$2,685, plus any incremental increases that are triggered in 2025.
What do you mean by that?
we might,
Fees and charges are reviewed annually. I haven't seen the new
Oh,
fees and
yeah.
charges for 2025 yet.
Right. Changes by council and budget.
Correct.
yeah, we confirm every year.
I don't have any other questions, Matt.
Further questions, councilors? Okay, we'll move on then. Thank you for that summary.
Okay. All right, so first we'll hear from the appellant, Mary Subadar, speaking in person today.
You have 10 minutes. Can you wait till? after
Thanks
she
for
finishes, Councillor?
listening to me.
Yes, go ahead.
I wrote something out, and I'm going to read it just in the interest of brevity.
Okay,
14 Riverside Drive is a one-story bungalow. Can you hear me?
yes, we can.
On the river in the heart of Fort Garry, an area not known for vacant building fires, as far as I know. I purchased this uninhabitable property in 2019. The agent did not even allow entry to view due to its state. The house prior to my purchase was a drug trafficking and chop house, hub for the neighborhood where police visited regularly, a large problem for the neighborhood at the time. I will read a statement from a resident of the neighborhood submitted to the city in November 2019 in another appeal regarding the taxes on this property. I quote, "For 2 years, we, along with other neighbors, monitored and reported illegal activities that occurred on that property. On most days, we personally sent as many as 3 emails to public safety and the Winnipeg Police Department, often with photos that chronicled the drug drops, bike chopping, and excessive pedestrian and car traffic that visited the property on a daily basis." End of quote. Police made arrests of individuals in and around the property who conducted the business there. This was well known in the Fort Garry area. The city would have been aware of this problem from its own police records and neighbor reports. Page 1 of your package, which I'm just going to refer to, is one of those many free press articles chronicling the issues with this property dating back to 2015, if not earlier. The house was on the market for some time before I bought it, unfortunately. Immediately upon purchase, I safetied the house at much cost on my own accord. The city did not ask me to do this. The riverbank was cleared of deadwood and debris, and years of overgrowth, which was a fire hazard, and which was also a deliberate cover for illicit activity, was cleared. I hauled away broken glass and truckloads of junk from both outside and inside, much of which was combustible at huge cost. Broken windows were boarded, as well as areas of visible forced entry to the rear. 24-hour surveillance signs were added, and a rear yard completely closed off with fencing. The lawn has been kept cut, signaling both surveillance and new ownership. I asked the neighbors to call me whenever they saw any activity in and around the house, and I would visit the site frequently. And they did call. They called regularly for probably about 6 months, and I went there. While activity was observed for a short period of time, probably 6 months after my purchase, it quickly came to a complete halt with all of my above interventions. The fencing was only recently breached, and coincidentally around the time that the city visited. It's a coincidence. I'm not accusing you of anything. but it has been up for 5 years. Police records would illustrate that no visits occurred any time after my ownership. In essence, the property was radically changed and the neighbors were relieved. This is what they told me. I have never gotten a call from a neighbor since 2019. Children play in the front yard. So notably, there is no city sidewalk or lane, and the property is set back, so no one traverses this property or comes near it. 5 years ago, I did what the city required all responsible owners to do regarding vacant buildings, evidenced by 4 years of absolutely no illicit or dangerous activity. Riverside Drive is now safer than it was prior to 2019 when it was a trafficking hub, despite the property going from occupied to vacant, which is kind of an irony. This is a unique situation and in contrast to other vacant properties. The items on the order I am appealing were present when I purchased the property, like eaves troughs and siding and ceilings. Those were derelict and broken when I purchased the property. As far as I know, no orders were issued or enforced prior to my ownership for repairs of all of these during the time the house was a trafficking house. Upon purchase, I also had an estimate done for demolition, and I completed a demolition application in 2019 and planned to immediately demo the house because of the condition of the house. The image of that is in your package. The demolition wasn't, I pulled that demolition. I called the city and I told them that I changed my mind, so I canceled the demolition intention at that time because of the cost of asbestos removal. I was informed about the asbestos removal requirement at that time from a contractor and was shocked at the cost. I understood that the city dumping fee is a large factor. So the demo was delayed at that time, primarily due to cost feasibility, including carrying costs for vacant buildings. The cost to remove the house, including asbestos, is between $45,000 and $50,000 for a single-family residence. I'm a designer and a renovator, and I've restored countless derelict properties in the Corridon area, demolishing some that were not restorable over 30 years. Riverside Drive is the first instance where demo was delayed due to government regulations and the costs that they incur. So, despite already successfully securing the building, I received an initial city notice in July regarding vacancy bylaws. I replied to the number on the letter to discuss my plans for demolition listed, but the city did not return any of my calls. In fact, no one has spoken to me about this property prior to the issuance of these 2 orders in December regarding assistance about moving forward with some kind of plan for the property. Instead, a process ensued to which I had to respond with inflexible deadlines over the Christmas holidays. 2 orders were issued in the beginning of December after a city inspection. The first order was to board. This was completed despite weather and the holidays. I have done the boarding in compliance with the bylaw. It's boarded with 3/4-inch ply and bolted and screwed almost every 6 inches as per city specs. It's braced as per city requirements so that the plywood cannot even be pried. I have not completed the requirement for painting, even though the city refused my request to extend this deadline because of winter. All doors are also bolted. Riverside Drive is now a fortress and is now more combustible with 19 sheets of plywood that I've added to the exterior, which was steel, glass, and stucco. In my professional opinion, the boarding is beyond what I've seen anywhere in the city, and I incurred another cost of $3,000 despite my own belief that it was unnecessary and that the property was safe. The invoice is evidenced in your package, and the extensive boarding that I've done is also in your package. The city has structures that are far, far worse, in conditions far worse than mine, and close to very public ways. I'm sure you're aware of it. Provenche Boulevard, which I've included, just 2 houses as an example with images, are part of your package. It's merely 2 examples. My house is boarded and it's secure. It's a fortress. The second order for repairs is the order that I'm appealing, to repair eaves, soffits, ceilings, siding, and remove combustibles. The house is obviously uninhabitable and slated for demo, so this order further drives up already mounting costs, and I feel it's largely unnecessary. The items listed pose no risk to the surrounding persons or property. There's no pools of water on sidewalks. Overall, the property is not outwardly unsightly even. Indeed, prior to it being boarded from the front, it could have passed as occupied. Regarding combustibles, significant debris was already hauled away. Am I almost out of time? The kitchen cupboards were detached so that there is, to prepare for asbestos removal, so that's remaining in the property, but largely it is empty. I feel that this property is falling into the snares of bylaws precipitated by dangerous properties and negligent owners in very specific areas of the city, which this property is not. It's safe, well-kept. It's a safe, well-kept site with no incidents since I bought it. Notably, I've never had a fire or break-in in any of my projects for 25 years, including this one. These bylaws, and in this case in particular, are making development of this property just less feasible. I'm in a bind with this property. I can't rent it because it's not inhabitable. It's not fit for human habitation. I can't demo it yet due to costs which are steadily rising. And I have done what I could to make the structure safe without any letters from the city back since 2019. The carrying costs such as taxes, hefty insurance, and the cost of demo and bylaws are the crux of the safety issue here. These are what are prolonging the vacancy period, not eaves, troughs, soffits, sidings, ceilings, and combustibles. So I kindly ask for relief from the second order for repairs of a derelict structure, since I complied with the first, which I largely found unnecessary. I also ask that the boarding fee be waived and the inspection fee be waived. I know it's a lot of asks. I'm almost done.
Do you need a 2-minute extension?
No,
Counselor
1
Schreier,
minute.
just move.
1
Okay,
minute.
well, we'll move it. Go ahead.
Okay.
Go ahead. Consensus.
Okay. I also ask that the boarding fee be waived and the inspection fee be waived, that I might put these funds toward demolition rather than adding more funds toward keeping an uninhabitable building standing. Rerouting funds earmarked for demolition keeps structures standing longer, which is itself a threat to fire. I ask that the city incentivize removal of this structure by assisting me with keeping these costs feasible. I realize that this may be precedent-setting, but I ask that the city work with people like myself, small developers working on very difficult projects. Thanks, I'm done.
There's a lot of questions for you.
Okay.
I saw Councillor Wyatt's hand go up first, then Councillor Schreier, then Councillor Eady's.
Thank you. You've owned the property since 2019, is that correct?
That's correct.
You've stated in your statement here, the words that you used, is slated for demo.
Yep.
When?
I don't have a date for that yet, and in 2019,
So it's not slated for demo?
it's not, well, it is going to be done.
You know what, Councillor Wyatt? Let her answer the question.
All right, Madam
First
Chair.
question, is it slated for demo? What's safe?
I don't have a date for it, but it will be demolished. And that was always the intention. When I bought it, I was going to tear it down because it's not habitable.
So it could be argued that it's not slated for demo.
Well, there's no date yet for demo.
Typically, when somebody says slated for demo, means that there's a date
Okay,
set for demo.
asked and answered. We got the answer. Councillor, other
No,
councillors?
I just want a clarification on that. Is it slated for demo?
She already asked that.
I intend on demoing the project, the
When?
property.
When?
I don't have a date.
Okay? Just to give you a bit of background here, when this bylaw was brought in by then Mayor Glenn Murray, we had a ton of appeals at this committee, similar to yours. And the committee in the past was prepared to exercise work where we would delay the exercising of the fees if we got a sense of a time frame that the building would be demoed or repaired or both, either one or the other. Do you have any way you can give this committee any kind of understanding of when are you going to do this? Otherwise, you're asking us to delay something which is, our staff are asking us to uphold a bylaw that we passed for this very reason.
I want to stress that no one from the city spoke to me about this property prior to me being here today.
They have spoken.
Regarding this. When I made phone calls regarding that first letter that came out in July, no one responded to my messages that were left on desks. And that's when I wanted to speak about demolition and a process of going forward. That didn't happen.
Filing a demolition permit is going down to the city and filing an application to demolish on Gary Street. You said you've done other projects like this. It
Yes.
sounds like you're familiar with that process
Yes.
then? So why would that be a surprise to you?
It's not a surprise to me. Filing a demolition permit isn't a surprise. I just wasn't prepared to file it yet because I don't have a date in my mind as to when that would occur. COVID happened, illness happened. I mean, there are personal issues here. So the building stood empty for some years due to personal health, as well as rising costs. And so
The value.
I
of-
don't have any better answer for you
What
with
is the
respect to the
assessed,
date.
what is the value of the land itself? You're on the river in a fairly nice neighborhood. Do you have any intention or any idea what you want to do there?
I would like to build an infill property on it. To live in, actually, it's for myself.
I see. So that you want to build an infill property that would be a single-family property at this
Yes.
location?
Yes,
I see.
in keeping with the neighborhood character. And this is the business that I'm in, and I have been in for 30 years. This is the only project that has been held up because of the cost, primarily initially, of the asbestos removal, which I haven't yet dealt with.
Okay.
But you're not able to give this committee any sort of time frame in terms of when you're going to be able to demolish this property and start construction of a new home?
Well, I wouldn't intend on holding it for more than 1 to 2 years longer in the condition that it's in.
And you've heard what the staff have said of the escalating fee that you'll have if that is the case?
Well, I think, I brought this property to your attention because I think the city has a problem. I mean, I am a planner, I'm a developer, I used to teach at the university, I retired due to health, and I look at these vacant buildings everywhere, and why are they standing? I'm an example of why they're standing. I'm a good example of why they're standing. I bought properties where I've demolished them within 6 months. I've turned properties over within 9 months to 2 years, sometimes 3 months even. This is the longest I've held a property, and it's only due to cost. And the costs are rising. And the more they're rising, the longer it's going to stand. And that's the fire hazard.
Yes and no. In the past, we
Okay.
have these rising costs.
You know what? Folks have questions,
I have a question.
and you're basically debating what you can
No,
do in your
no, I do have a
concluding
question, but I have a preamble to my question.
Like, if I don't have 50,000 to take the building down now, I don't have it.
Well, and that's
So I
why
can't
we
give
have
you, I
these,
can't give you a date.
and are you aware, we have these fees in place
Councilor
that we
Wyatt,
can,
You're debating.
no, I'm asking,
This
are you
isn't a
a
question. And others have questions.
Okay, I'm going to be quick. Are you aware that we have these fees in place to motivate and to make it possible for these properties to get moving in terms of demolition and/or restoration, so that we can actually see a change on the property, and that the bylaw has actually worked quite effectively to facilitate that?
Yes.
Councillor Schreier, then Councillor Edie, I think it was.
Sure, thank you very much. First of all, in your explanations, I'm sure I'm not the only one, I'm going to speak for everybody, but I'm sure I'm not the only one who appreciates your work in trying to make the building safe during the process before which you begin your development. It's important to people, and thank you. That doesn't always happen. Got some questions here. So did you know or did you not know about the existence of asbestos in the building when you bought it?
Absolutely not, otherwise I would have not bought it.
Okay. And it is the prerogative of a potential house buyer, a building buyer,
Right.
the prerogative to get what would you get it? What would you get?
An inspection.
An inspector, yeah,
Yep.
official licensed
Yep.
certified inspector,
Yep,
and that did not happen in this case?
it did not.
Okay, so in this case, there was no inspector, and we lost the understanding of the asbestos when you bought it. Okay, fair enough. And how many years did you own it after which you were told about the city's wish for you to make repairs to the place? I think you mentioned the soffits
That's just this December.
after buying it in 2019. Okay,
I didn't get any notices from the city until this past December. And the boarding, I did already. The second eaves troughs, ceilings, downspouts, that I'd never heard of before.
okay, so they waited 5 years to tell you about that. Okay.
Yes.
And you said, however, that over the years, I'm not sure when, you've made numerous attempts to communicate with the administration and that you did not receive response. Do you have could you explain that attempt for communication? You said left on their desk or something like that.
No, I didn't. I didn't say that. The letter that was sent out in July,
What did I hear then?
Yeah, you did hear left on their desk.
Okay,
did I say left on a desk?
Yeah. You
I said left on a
could have been
voicemail.
figuratively.
yeah, that makes sense.
I'm sorry.
Yeah, that makes
Yeah,
sense to me. Left
yeah,
on-
I left messages on voicemail when that, and when the first letter came out in, I guess it would be July,
Okay, so,
but no one responded to that.
okay. Did you receive any communication from them this year before you left that call for them?
Before this meeting, I spoke with Corey, I believe. Corey called me 10 days ago to inform me about this procedure and ask me what my side of the story is.
Okay,
It wasn't a planning discussion of, what do you intend to do and can we work with you? It was not that kind of that wasn't the intention.
okay. And when did you get notice about their concerns for repairs to the soffits and things like that?
That was also in December,
Just
December the 4th.
last
yeah.
month?
Yep.
So when you tried to communicate with them in July, did you say?
Yes.
In July. Was that before they had any communication with you this year? Was that?
Yes.
So you initiated that communication, had nothing to do with
No,
responding?
I'm sorry. I was, when I communicated with them, I was responding to a letter that I got in July.
Okay,
They sent me, there was 5 years of nothing. Then I got a letter in July, and I called and left a message wanting, I think it's twice, I left a voicemail for somebody to call me to explain to me what this bylaw means, because it was this package of vacant buildings bylaw, which was pretty hefty and very complex. And I wanted the city to know that I was demolishing the building and to have some discussion of what to do going forward. But that didn't happen.
okay. So you were hoping for some assistance in terms of advice from the city?
Right,
terms
because
of how to deal with the
because of
cities.
the asbestos, because like, how do I feel like I'm in a bind and I don't know. I have this building, you wouldn't want it. I have it, the costs are piling up on it, and I don't have the money to take it down right now.
Understand. And now you've been doing this for numerous years, ma'am?
30 years. yeah.
30 years, you've been buying buildings, you've been renovating them or demolishing and building new buildings. You've been doing this for 30 years in Winnipeg?
That's right,
Okay,
primarily in Corridon.
okay, fair enough.
Yeah.
In the past, has the administration been responsive to your questions, if you have any, regarding your ability to adhere to city bylaws?
Well, I'll give you
codes?
2 examples. I got a similar bylaw order for 237 Lanark. And when I got the bylaw, the package of vacant buildings, in a month, I just took the building down. That's all I did. I thought, okay, I don't want a vacant building standing. This is going to be complex. So I applied for a demolition permit and I took it down. 383 Harrow, I did the same thing. I just got a notice from the city, this package of bylaws, and I took it down.
What was,
383 Harrow, 237 Lanark. Those are
So
2 examples.
what was the year or the month or the date of 237 Lanark regarding the letter you received and then your demolition of the place?
I'm sorry, I don't have that in front of me.
Okay. And
But
in
was
those,
it prior to this one, if I can piggyback on Counselor Shire's?
It's quite, it's
a while ago,
a decade ago,
yeah. Okay, so.
some time ago.
In this case, in the other case, you sort of sidestepped it by completely adhering,
Yes.
by demolishing.
Yes.
So you don't have to deal with that, you just.
That's right,
you can-
exactly.
In this case, you had what you didn't know when you purchased,
Yeah,
but you have what's publicly known as a hazard, environmental hazard.
Right.
Health hazard. Health
Right.
hazard,
Yep.
and thus you wanted an understanding from the city in terms of how you comply.
right,
I get-
because one question I had for the city, and I didn't know whether I could even bring it up here, because I'm really appealing the extensive repairs that's now required to be done, which is if I could do a wet demolition rather than hand removing everything out. I don't know if you are the people to ask that to bring the cost of asbestos down. Spray the building and then take it down versus, I think it was just done recently.
Wet demolition is 50 grand.
Yeah, but it's asbestos is federal. Okay, any further questions?
Yeah, I'm good for now, thank you.
Okay, Counselor Edie, and then back to Counselor Wyatt.
Yeah, so you've been in this, business for 30 years.
Yep.
Did you, when you made an offer to purchase on this building, did you not want to have it inspected for any hazards that it's buyer beware? Did you make it subject to inspection to ensure there was no asbestos? Because that's usually what happens, right?
In 30 years, I've never hired an inspector.
Okay.
So you never had the building inspected for any problems, which you assumed on sale, you assumed all the liability for that property, right? So you never had that, that's not your practice to,
Well, in my experience, the demolition costs weren't what they are now.
well,
And prices have gone up substantially. And that I couldn't anticipate. And as a graduate architect, I could typically walk around the inside of a building myself
you wouldn't find it.
and have a good idea of what I needed to do, whether I could restore it or whether it has to come down, whether it's not fit for human habitation. And so in this case, I did ask the realtor to enter, but she said, no, it's just too dangerous. So I bought it sight unseen on the inside.
Too deep.
I never did see the inside of it when I
Right.
bought it.
All right, okay, and this is after you've purchased properties on Lanark and all these other places you're
Yes.
talking about. And by the way, you're getting those properties, those are really nice streets, right? So, and so is this one. So the value of whatever gets built new is going to be pretty high, I would say, wouldn't you? Yeah? Once you're able to tear it down, right?
Well, the cost of building is pretty high.
Yeah, that's right. Well, homes along the Red River up in my ward are going for $500,000 or more, so. And it's about $380 to build new, I think. Anyway. So what I'm trying to get at here is, first thing, so you realize it was stated by our public service that vacant derelict buildings and this, it's all complaints-based. The city doesn't have the staff to go around the whole city looking for these things. What ends up happening is somebody files a complaint, and that's why the city shows up. So you understand that, right?
I do understand that, and perhaps it's something that the city needs to look at. Like, if you're going to apply laws to citizens based on, the beef I have with my neighbor, I don't think that that's very democratic. I mean, it's just an opinion.
Well,
Like,
it's complaints, everything we do
then
is
it allows,
complaints-based,
then it
right?
just, it sort of
Bylaw
based
enforcement
your,
is all
base,
complaints-based.
it bases, right? And that's kind of what I'm I mean, it's a good forum to address
All right,
this.
so nobody,
Whether is it safety or is it one particular person?
it's okay, but what I'm saying is somebody filed a complaint.
Yeah.
That's why nobody showed up till 2024.
Okay,
Now, like you said, you were taking care of the property. That's
Yes.
great. I'm not, and it's unfortunate that there was health problems and all that kind of stuff. But what I'm getting at here is, so, although it might have been hard to make money during COVID, the point is since 2019, you know that there's asbestos in this house, right?
that's correct.
Okay. Have you made any attempt to save up the money that you need to do a wet demolition of this building?
I think that's a very personal question.
Okay.
And
I'll-
I would
I'll
I'd rather
speak
really
about it.
not answer it,
that's
because
fine.
that's not what I'm appealing here. I'm appealing the logic of
Mm-hmm.
fixing eavesdrops on a building that is coming down.
Well,
And the eavesdrop, actually, there's just one spot in the back. If you look at the pictures I've submitted, it's in relatively good shape. And before I put the boarding on the front, if you did a cursory drive-by, you wouldn't know that it wasn't uninhabited.
right.
And I blocked off the back. There's no access to the back. No one can see the back of this building. So
Right.
that's, I'm here really to discuss, like, what is the logic, the city's logic
Well,
in
let me explain.
asking?
Okay, I'm going to ask you
Wait.
this question. No, I'm going to ask her by question
No, it
because
doesn't.
I think she has a false impression about
Right,
other
and
vacant
you can say
houses
that in
around
your
the
summary.
city.
You don't
And
need to
so-
debate right now. You can say it in your summary after.
I will say it
there's
in the
other
summary, but I
questions.
just,
You're
well,
debating.
all right, never mind.
You're debating, Counselor Edie.
Never
and-
mind.
And so is she.
Okay.
And I think if you have a question, yeah, there are other questions. Counselor Wyatt, are there questions?
I just had one, kind of a follow-up to Councillor Edie's, which is
Really, it's a statement.
the complaint-based system,
Oh, my God.
even though it may be random, even though it may be arbitrary, as kind of you've alluded to, basically what it means when the administration says that, are you aware that it means that there's probably a resident or residents in the area who have complained about the property
Question
enough?
or an explanation?
I'm asking the
Because
question, are you aware that there are residents in the area that have complained, or residents who have complained about the state of the property and wanting the city to do something about either upgrading the property so that it's habitable or livable or safe and/or demo? Do you understand what that's about?
I feel a little bit like I'm on
Yeah,
trial.
that's
No,
fair,
I'm just
because
curious.
she's actually answered that question, gentlemen.
All right.
Actually, you are engaging in debate with her.
No,
and
no,
that
I'm
is
just
not
curious.
this forum.
Do you understand there's residents who aren't in this room today who are probably
Then
complaining?
you failed to listen when she said she knows it's a complaint-based, and in fact, that's why she's here, to hold a mirror up, and she in fact not only illustrated it with an example that she stated on the record just about 10 minutes ago. Well, I was here and I heard her say it.
Question, Madam?
Is it a question, or are you
question.
explaining something?
Give us any indication of when you're going to file for a demolition permit?
Asked and answered again, gentlemen. You've,
Well,
all-
it's important because I like to be able to give the benefit of the doubt as much as possible to the appellant if I understand if the appellant's going to be filing a demolition permit for demolishing this building within the next number of months.
I've heard the appellant say multiple times that she
I
doesn't
just want to
know.
verify that.
I will leave it to her if she wants to answer the question.
I said originally, I can't give you a specific date. I said that various times.
I'll believe you.
I also said that when you badgered me, I said within 1 to 2 years. I can't see myself keeping this building within.
Counselor Wyatt, I actually believe you are. And so, Counselor Wyatt, literally, and I'll say, I do appreciate your patience because I'm at my patience on the decorum in this room. You're arguing with the appellant. That is a thinly veiled question that it looks more like a lecture to this chair. Really? She asked and answered, right? She came with a perspective.
You know, can I say something?
Your job is to have an open mind and to listen. And that's in our procedural bylaw. Okay.
Can I make a point of order?
Yes, you may. You can challenge the chair if you want, Councillor Eady.
This appellant came to the podium and stated how righteous she is.
Sorry,
And
that's
so
beyond the
why
pale.
can't I-
That's a point of order. That's a point of order, because you are impugning and saying,
She used as an argument how
You-
righteous she is,
sorry,
taking care of this building.
you're characterizing her arguments as righteous.
Didn't
you're
you hear
char-
her speak?
Councillor Eady,
I give up. All right, Madam Chair, you take care of it, run the rest of it. I'll be making a motion. Let's go.
you're not, I apologize. I don't think that is I don't think it is fair
Is this the,
to call you righteous. I believe you're just forwarding arguments. I don't have any questions for you. Does anyone else have questions? Otherwise,
I do for the administration.
okay. Thank you for your time today. I don't see any further questions. If you want to, unless you have something to add in 30 seconds or less.
I thank you for listening to me. I came here in good faith to bring forward, I mean, I didn't have high hopes at all. And I took the time to write out something to read to you because I think that this structure falls in the crosshairs of something that the city needs to look at broadly. It's not just this house. It's small developers like myself that are improving the city. And that's not righteous, it's a fact. Tom Montaigne was a classmate of mine that you just heard. He's doing the same thing. And he told me he would like to stand here and support my appeal, but he couldn't stay because he's in the same boat. A lot of us are in the same boat with the rising costs of development and trying to do our jobs. So, yeah, that's all that I have to say.
Thank you very much. If you'll take a few more questions, Councillor Schreier has a few more questions, but please make them questions, not statements.
Sure. One is, okay, going back, just so there's clarification, because
Yep.
I'm not exactly sure how many attempts to communicate with the administration that you had. In July, you started communicating with the administration. You said it was a telephone call. Was there more than one telephone call? Were there emails involved? Because I have to
No.
ask the administration if they were aware of any attempt from communication on your part.
I just replied with 2 attempts to leave messages.
A-
Not
attempt-
attempts, two messages that I
messages
left
left.
in July. That's it. And prior to that, nothing. There was no communication with the city whatsoever.
Do you know what office that was to which you left those phone messages?
It would be the bylaw office,
Bylaw
because
office.
those are the only offices that I got letters from.
Okay. And so you're saying that the reason we're here today, the reason you're here today,
Yeah.
that this has all happened because of, well, you're explaining, you bothered to say it a couple of times, you weren't ruled out of order, it's important stuff here. You're saying it's because of the cost of development. Can you say
Well,
what is
the cost, I'm not even appealing the boarding order. I went ahead and I complied with your order to board with 3/4-inch plywood, with bolts, 19 sheets of plywood. I did that, okay? What I'm appealing is the repairs on a structure that's uninhabitable. And it's not necessary because it's not posing any personal risk to people or property at this point. There's one spot where there's an eavesdrops at the very back. It's not draining to anything.
Yeah. Okay.
There's a bit of falling siding. The building is actually in relatively good shape. So,
Right. Thank
Yeah.
you very much.
Thank you very much for your time today. We'll move on to questions for the administration. Councillor Schreier, you said you had some.
Sure. I think we're in a gray area here. Well, again, just like I did with the last one, I can see where Councillor Rowlands was coming from in the last hearing as well, with Mr. Montaigne. Again, it's, as he said, a way of showing a complaint. I get it. In this case, too, just trying to get things straight, whether there's an exception to this in one way or the other regarding this place. It is unusual compared to where I live. I live a block from Redwood in Maine. So, can be different. And how much time, when did we find out there was a problem with the eaves troughs and that kind of thing regarding this building?
So back to process-wise, once we receive a complaint, we try to work with the property owner as best we can. As you can understand, sometimes they're not available, they don't return our phone calls, they don't try to get in contact with us. Normally, when we actually hear from them is when we send out orders or tell them that we're going to do the inspection, this, that, and the other thing. So what I can tell you with respect to this property is we received the complaint in June, sent out.
There is no room for you to rebuttal, so you can sit right back down, okay?
There will be later, right?
Yeah, not right now.
Sent out the information package July 17th, as the appellant confirms. And then we did our Schedule A inspection in December. Prior to that as well, prior to us actually doing an inspection, we send out something called a RTE, which is a request to enter. Again, we notify via registered mail of the property owner that we are going to do that inspection.
And there was an RTE, there is a request to enter?
Yes.
For inspection, when was that given?
Corey? Is he still there? Oh.
Sorry, just giving it a second to connect. The question regarding the RTE being sent, it was, give me 1 second, issued November 5th, delivered November 7th.
November 5th, okay, all right, that's fine. So 6 months ago, in this case, the requests made presumably, if not stated specifically, due to complaints from the neighborhood. That is right?
What was the question? Sorry, was it?
That there was, that communication with the owner of this address started in June due to complaints made from neighbors.
No, so we
Okay.
received a complaint via 311. It doesn't say that it's from a neighbor
Okay.
or their neighborhood.
Excuse me.
Again, that has to be very clear. We do not disclose where we've received it from.
Right.
But 311 gives us a complaint
Yes.
for investigation, and that's what we would go out to investigate.
And how long did you take between receiving that call and an investigation?
We received the complaint June 22nd. We did an on-site inspection July 5th. We declared it vacant July 17th. Sent out the information package July 17th.
Okay. So within less than a month, things were happening from your end. So I'm just looking at, and I feel I need to do this in terms of where one stands with this all the time. Is this the way it always is?
Yes.
Within a month?
Well, we obviously have a process. It's not arbitrary. We have a process in place that our officers follow. Summertime is busy, right? Spring, summer is busy for us. So again, all depends on what's on the officer's list. We call it a to-do list. That's normally kind of what happens.
Okay. So, and I'm going to admit, when it comes to these things, it can get really complex, and I want to let you know sort of where I'm coming from here. We're in a gray area because we deal with this all the time. As a committee, in my neighborhood, as a counselor, as a council. And in this case, it looked like it was pretty fast. You got a complaint, and a month later, you're on it. 6 months later, we're here dealing with an appeal to that fine. You're saying it's not always the same. There's a process. It's not arbitrary, but there's a process. So I'm just want to see how it is that's being applied fairly in this case. And I understand it's a gray area. I get it, kind of thing. And that's where I'm coming from. As an example, sorry for being specific, but I've got three lots in my neighborhood, 4-minute walk from my house. 3 lots in a row is the same. Just so I understand, the process is the same process being applied there, where you got these burnt-out houses, the fences aren't done properly. That's a mess. I don't look at this one and say, oh my God, what a problem for the neighborhood. That's not how I see this one. Those I certainly do. And I feel sorry for the people that live right next door and across the street. I feel absolutely, it's terrible. This, I don't see it. My point is, in comparison, how do we say this is the one we got to get? Because we're talking about a lot of money on someone who's got a lot of costs involved already. And so I just want to see like, why this one? If you could say, well, it's proper, it's fair, this is our time process all the time, okay. But I got to ask this question because this is a huge question for us and in my neighborhood, in my ward, my general area of the city as an example. And this doesn't fall into my perception of a problem, like a real problem. I understand there's rules with the
I
city.
have a question, Councilor.
Yeah, my question is, did we apply there the same way we're applying here, like after a month of a complaint, communication with the owner, and within 6 months, we're up regarding appeals for fines?
So if your question is, did we apply it the same to your properties in your neighborhood? I don't think that is very relevant. And you talk about a gray area, it's not gray. Okay. So I think I've answered your question, Councillor, in saying we have a process. When we receive a complaint, our officers have a to-do list, which they manage themselves. If you say specifically in a month, are we getting out to every vacant building complaint that we have? No. We have a process in place where we receive a complaint, we investigate the complaint, then we do our enforcement process, which means we notify the property owner, we send out the brochures, all the information, we try to stimulate that communication so that we can figure out what's going on with the property. So there are different timeframes, yes, but again, it's not gray, it's not arbitrary. We apply it fairly and consistently across the city.
Okay. I have to say, there's certain types of things in which we have to make an arbitrary decision sometimes. Arbitrariness does happen. Sometimes we have to make a decision because things don't fall totally within the rules. In fact, I think we were just told that in our last one.
Do you have
That
another
was
question?
sure. To the extent this is not, I never said it was arbitrary, but a gray area, I guess. Well, okay.
Did.
To the extent it's not in a gray area, how is this one different from the one? How are the ones on Coburg different from the ones on Riverside Drive here?
So that's not before us
He's not
today.
going to tell you that. I got
All
a
right.
specific question.
All right,
Okay,
but
so does
that's how I think.
Councillor Wyatt. Yeah, sorry, Councillor Edie.
No, I just want to thank the staff for doing what they can with the resources they have. I worked with Gary Sokolsky extensively when it first rolled out this bylaw. The question I have is this, just to confirm, where we would grant time in the past is where an appellant indicated they had a plan either for demolition or redevelopment of the site or a development permit. Have we as a city, just to verify, I know I asked you this before, but I just want to confirm, have we in any way, shape, or form, or received any sort of indication formally from the property owner that they wish to file a demolition permit, or they have filed a demolition permit, or an outline of one, or a development plan? Have we received anything to that extent? Because that's the only grounds that typically we will grant. In the past, we grant extensions of time to try to work with the property owner. Have we received anything at this point?
So from my understanding, the communication that our enforcement coordinator has had with the appellant, she had indicated that that was her intent. When we have an appellant having communicate that to us, the first thing that we'll do is check our system to see what has been done, what has been applied for, right? because you can understand we hear a lot of that. And then just further to that, even though a demo permit has been applied for, it doesn't necessarily stop our process as well. Because the demo permit does have a time frame with that as well. So, and again, it could be 6 months, or it's still vacant. It still has the risk, and we still have to do our assessment of the property. I just want to come back to, we're here today for the appeal of the order stating the deficiencies.
Right.
So that's kind of what we're here for and what we're talking about. The order itself identifies all the deficiencies in the vacant building in order for the property owner to understand the risks that are associated with that building, and/or our first responders, and/or for the community, because we post our orders to the public domain as well. So people can understand that it's a vacant building, the city is aware of it, the city is doing enforcement of it.
But we have received nothing in writing. Verbally, you've heard it from the property owner, but nothing in writing at this point.
Correct.
Thank you.
Councillor Edie.
So a number of the items that the order has, it's kind of the, I wouldn't call them an emergency, but I'm not sure, Mr. Miller, but I believe when the neighborhood livability stuff was put in there regarding exterior measures, was that also not put in there because homes that are decrepit and not looking very good take down the value of the neighboring properties?
So the vacant building bylaw is separate from the neighborhood livability bylaw, but the neighborhood, or the vacant building bylaw addresses issues of property standards. So that's what the Schedule A inspection is. And
Just the
again,
property
it outlines all the deficiencies, similar to what a neighborhood livability order would be as well. Just again, neighborhood livability is about normally owner occupied, and again, vacant buildings obviously are vacant.
Right. The appellant noted, and I'm not sure, like I've heard it on livability, but the appellant stated they requested for exterior work to be able to do it after the winter because they're not going to do that work in the winter. Was there, did our bylaw enforcement consider extending compliance date?
The compliance date for the actual work to be done, so eavesdropping, that sort of stuff, would be subsequent to the following Schedule A inspection. And I'll let Corey jump in there if I'm incorrect. So it's a little bit different from the neighborhood livability stuff where, let's say we get a complaint about paint chipping in the winter, right? Which we've heard a number of years ago. We don't say, well, you have to paint next week, right? Because again, it's not feasible to paint in the winter, right? We would put a compliance date of, at a couple months or something along those lines, right? Even that as well, with our compliance dates, if the property owner is, communicating with us, is doing some sort of repairs, this, that, and the other thing, we tend to try to work with them about it. A compliance date is just a date that gives them that once it expires, then we can go into enforcement, which would be, tickets, some remediation that we can do, like grass and garbage, that sort of stuff.
So Corey's going to give us an idea what compliance dates are going on here?
Certainly, I can then provide some context to that. And in the context of what I think I heard from the appellant, she had mentioned that they hadn't done painting of the boards that have been applied as part of the vacant security. And that's certainly something we would take into account and look, as Mr. Miller indicated, to the springtime for them to have the opportunity to do that painting. We would not issue tickets or enforcement on that until there was an opportunity to do it in a reasonable manner. In terms of compliance dates, the compliance date on this order is January 6th of 2025. We're not currently doing anything because it's under appeal, but we would look to re-engage with it depending on what the committee's decision is. The opportunity is there to work with the owner, to give them time to become compliant, depending on the committee's decision.
Okay, all right. So, well, goes more to the, well, I don't, you, enforcement has experience. I'm gonna, you could rule me out of order, whatever, I don't know, but I'm like, I feel, I have an understanding of people who have these homes and buildings, and it doesn't matter where it is. It could be on Riverside or it could be on Manitoba Avenue. And sometimes they're working at trying to improve the property while at the same time having to pay all these fees. I'm just curious, how many times, I know it's not specific, but how often do you hear that kind of argument from the people? I hear it quite often in my office, but is that a fair question to ask, Mr. Miller? I don't know.
Everybody has their own set of circumstances. We encourage and want communication. Obviously, we're empathetic to people's plights. Ultimately, a vacant building is a secondary home for the most part, right? So people have purchased these homes, whether it be speculation, whether it be for some other usage, but for the most part, it's a secondary home, which means, again, that they have another home, or they have some sort of enough disposable income to purchase homes, right? So, so again, back to your question, we hear everything when it comes to why people have a vacant building. But I'll be quite honest and frank with you. For the most part, 90% of the times we don't hear from people who own vacant buildings. And that's why our vacant building is so strong, to eliminate the issues and risks that occur with vacant buildings.
Okay, that's all the questions I have, thanks.
Okay, if there's nothing further, we'll move on. There is an opportunity, though, for you to rebut anything that you've heard on the record. Is that right? But before you do that, we'll do a quick call out in the case someone's here or online. I'll turn it back to Leah Cowan.
Just confirming that no one in the gallery is looking to speak in support of or in opposition to this appeal.
Okay, go ahead on what you've heard.
I just wanted to stress the fact that the city, I'll say this again, I said it before, the city did not make any attempt to reach out to me by phone or direct email to talk to me about this property. I got registered letters in the mail. And I know that the gentleman mentioned that they do make an effort to contact owners, but in my case, they did not. They sent me out a copy of essentially vacant building bylaw in July, and what that means and what costs can be incurred, and that they had intended on doing some kind of inspection on a later date. That's all that I got from the city until December.
That was her opportunity to rebut. You want to ask questions at this juncture?
So her rebuttal may not include answering questions at this time, lest we go to...
You can do it again. We can do it. There is no cycle to which we have to stop here. You can ask her questions.
Yeah.
We can go back to the administration.
So, if I may ask a question then, a couple of questions. One, so your response to that package you received in July was a phone call. You didn't respond in writing to the address?
No, because there wasn't anything really specific. It was a generic document they sent to me that had to do with the vacant buildings bylaw. Mm-hmm. And I didn't know precisely how I would my property was falling in line with that. I didn't know that there was a complaint. Nobody ever, I heard that there was a complaint this morning
Okay.
with respect to the property. And I heard that there were deficiencies with the property, specific deficiencies with the property a month ago, a month and a half ago.
Okay. And would you have preferred to discuss these, what was it called? Would you call them deformities?
Deficiencies.
Deficiencies? And information, would you have preferred to have communication with that in the summertime?
Absolutely. When my contractors, it would have been reasonable to ask them to go and do work.
Okay.
It was an unreasonable time frame to send me out a generic information package, not telling me anything, not answer my phone call, and then send me an authoritative order in the middle of December and say that I have to do it, comply over the Christmas holidays.
Now, you've been doing this for 30 years. Have there been cases in which you've received information and you've called them and you've discussed things?
I have avoided dealing with the city. That's why I demolished those buildings.
Okay,
And, yeah,
all right. Thank you.
you're welcome.
Are there any further questions at this juncture? Okay. If not, we'll move into motions.
Oh, yeah, so we've already asked if there's anybody. Come on, okay, I'm ready to move a motion then.
Okay.
I move that the receipt of public presentations be concluded.
All those in favor?
I
And that's carried unanimously.
I move, that the appeal be denied and the order of the, there's a long, that the
Yeah.
support worker licensing and bylaw enforcement, community services department be confirmed. I think
Okay.
that's right.
All-
Okay.
All those in favor, any comments on the motion?
I guess I should give an explanation.
That'd be good.
Contrary to how you might have heard me in the public here at the committee, Madam Chairperson, I do hear from property owners about these problems all the time, and it's similar. The vacant derelict houses are not different in neighborhoods in William White or Fort Garry. They all end up with these problems, and there are people who like to take on and want to try to improve the neighborhood, and they'll purchase a property and try to do their thing. But when it comes right down to it, though, we have set up the vacant derelict, and maybe there is a need at some point for us to re-examine the policy and how we deal with it, because the underlying problem for all of these situations, the biggest problem is a lack of money in order to get things done. And so, but given that, we do have, when we don't want to have vacant derelict homes in anywhere, and the order regarding this is, well, there are some situations, I won't get into all of it, but the public service in this case has applied things appropriately, and I believe as it moves in the future, the appellant will have the ability to dialogue with bylaw enforcement about the dates in which they can be compliant on various issues that are listed out in the order. So I don't think like some exterior work is going to be expected in the winter. So for those reasons, Madam Chairperson, I'm denying the appeal.
Comments, Councillor Wyatt.
Yeah, thanks, Madam Chairperson. I'll be supporting the motion by Councillor Eady. I would like to thank the staff for their input on this and for their work on it. The bylaw was written to encourage, to motivate, to foresee, to undertake or ensure that repairs are made on properties that are vacant or derelict and/or ultimately see their demolition. In the event that the property owner is incapable financially or otherwise to be able to do those sorts of works, the bylaw is there to encourage also the property transition to a new property owner who is capable financially of undertaking said works. That's not the responsibility of the city, but the city does need to enforce vacant and derelict buildings. We have them across our city. And I see the importance of us upholding the bylaw, the intent of the bylaw, which Councillor Eadie's motion does today. And the only thing I would, I guess, differ in Councillor Eadie's comments to what I would say is that this neighborhood does have inherent value in it in the sense of its location. The land itself has value in terms of its location on the river, and that there could easily be put together a business plan for the redevelopment of this site. In some ways easier than if it were located in a different neighborhood of the city. I won't name the neighborhood, but other than the fact that the ability to redevelop this site may be easier than it is sometimes in other areas. And so I want to thank the staff for enforcing this, for acting with the resources that they have, and for informing the committee of the importance of us upholding the bylaw. Thank you.
Councillor Schreier, with respect to the motion?
Yeah, in this case, it's really a close call to me, as they often are in these hearings. And I know that should sound funny, that we should have close calls or divided votes at appeals, because we have got a system. Having said that, things do end up at hearings for a reason, almost every single time. In this case, I'm going to say a few things. One, buyer beware. It was incumbent upon the new owner to know about the asbestos. You can forego, I've done it too. If you really know what you're doing, you can forego an inspector sometimes, but this one is an unfortunate one. Nonetheless, had to be dealt with sooner or later. In this case, I'm going to say that as a derelict house, I'm just going to say it, this is one of the nicest looking derelict houses that comes around. I mean, I know that sounds like a funny thing to say, but it means something to me given what I see every day. And just for living in my neighborhood. And on that basis, Councillor Wyatt made the point thanking the administration for doing this based on the resources they have. Why would we have to thank them for doing this based on the resources we have? That doesn't make any sense to me, unless we've got a problem with resources. So I'm going to take, if there's any credit to be taken, any acknowledgement of your welcome to Councillor Wyatt's statement, that is an acknowledgement of lack of resources. No one said his statement was wrong. Therefore, why are we thanking people for getting things done given the state of resources? Because maybe we don't always get our stuff done. Maybe there is an unfortunate delay in bylaw enforcement. And if that is the case, if there are lack of resources, well, hats off to the administration for continuing to do their work, despite what I just heard was an implication of a lack of resources. So when there is lack of resources, and it happens in departments throughout the city, less resources, until we say, well, scrap that department, we don't need it, get rid of it, because, it's not even working well anyway. When it comes to issues of development, how far do you want to go? By reducing resources. I know the fact that lack of resources has influenced. Sure, this touches to something really important. Lack of resources. So we end up, and I'm sorry, apparently if there's lack of resources, then we have to choose which ones we're going to move on at that time. So we've got to make decisions. I'm not saying they're not all moved on, but if there are lack of resources, then why this one is what I've got to say. And it's unfortunate. I've got to make a judgment call on this one. But things come to me from what I see on a daily basis, and from what I heard here, including a thank you from Councillor Wyatt, just as an aside, on doing this given the resources. which means to me relative lack of resources. Otherwise, it wouldn't have been said. And I want to make a point as well. Yeah, I mean, maybe I need to learn something, but council does. And I would say therefore, we as City Hall do. I'm going to make another point, that this is the second time today that construction inflation, the change in the rate, in the cost of development. Therefore, construction inflation has been called a factor in the cause of the appeal. I just want to make that point. We should all learn from that. And if we don't, why are we here? So that one's kind of big. I mean, that's gigantic, okay? Also, I'll say it again. 2 appellants today made the point that a change in the cost of development, construction inflation, is the reason for these appeals. It's a factor in the appeal. Well, I've been predicting this for years, right? How sustainable this is. So there you go, another example. So in this case, I'm just going to make the point that within this gray area that we deal with on appeals, and I've been saying this since day one for 10 years, 60-40, 55-45, this is a really close call, but I'm going to side on the appellant on this one.
Okay. Thank you. I'll be supporting the motion. You know, there are many people who have bought property and are rethinking owning a vacant property in this city. And in part, that was the point of the toughening up of the bylaws. It is a response by council in part, and I'll speak for myself, to the financialization of housing, the safety of our firefighters, and responding to vacant buildings, the time and the effort required to respond to them. For sure because of complaints, sometimes because of fires, sometimes because of both. So the financialization does give pause. The matter before us today, with respect to deficiencies, just on the face of it, there were no plans to deal with them. And in part, there's no timeline either. That's a bit troubling when there's been a history in the neighborhood of a home, and yes, both things can be true. A new owner can mean perhaps less complaints, less dereliction, but it doesn't mean for the neighborhood that that's no less vacant and there's no timeline for it to be used. And that social good is what many Winnipeggers are in fact underlining for us and for the city, which is stop with the financialization of housing, stop with the prospecting because there's a housing crisis, and we want neighbors. We don't want empty houses. So to that end, on the file, we do see that there were 2 calls, there were emails, and there were 3 in-site visits, and it sounds like those on-site visits won't end. That will be increasing administration because we have directed the administration to go out because firefighters are falling through floors in this city. We have a city that does not want any more vacancies. And while we do want people to purchase, and I appreciate that there is some irony and contradictions of policy, I don't find it ironic when it's been vacant since 2019 and there's still no plans. I do want to add, we have had meetings with the province, who is the authority on asbestos remediation, because that was a complaint that rings true in terms of the costliness, the timeliness involved in asbestos. There is policy work to do here, but this isn't, this would not have, in terms of the arguments forward, I'll be supporting the motion. I will call the question. All those in favor? Aye. Any opposed?
Aye.
You're changing your mind? Okay, that was carried.
I was in favor of the appellant.
Okay, yes, I heard that. So with Councillor Schreier marked in opposition, and then we'll do the final, close out the hearing. You'll close out the hearing?
I got one more motion here. I move that the appeal hearing be concluded.
All those in favor?
Aye.
Any opposed? That was carried unanimously.
Please note that the committee has made a final decision on this matter, which is not subject to further appeal.
We'll go into the final appeal hearing, and we'll say goodbye to Councillor Wyatt. Do you need a 5-minute break?
Yep.
Can we do it in 15 minutes, or what do you want to do, Councillor Edie? I appreciate it's lunchtime. 30 minutes? Okay.
Yep, I got to eat.
We'll take a 30-minute break, and we'll come back at 2:05. Welcome back to the final item for Property and Development Appeals meeting for January 20th. We're moving into the item on 786 Main Street, and thanks for everyone that has watched so far. We'll move into a summary from the administration, and then I know the appellants are here and they can make their way down if they want to wait on the bench. But a review from the administration would be appreciated.
I'm going to turn this one over to Chief of Commercial Building Inspections, James Cameron.
Mr. Cameron, welcome.
Good afternoon, everyone. Madam Chair, councillors, clerk committee, or committee clerk, sorry, and friends and colleagues here in the chamber. My name is James Cameron, Chief Commercial Building Inspector for Planning, Property and Development. The building we're here to talk about is 786 Main Street. It's the New West Hotel. As everyone may know, it's sitting at the corner of Main and Sutherland, across the street from the Sutherland Hotel that we all read about in the news last week. It's a Division 1, 4304 compliant building under the Residential Buildings Fire Safety Bylaw, 4304-86. It has an active file dated November 16, 2018. It's a 3-story hotel with a basement, 2 shared interior exit stairs, and 2 fire escapes on the exterior leading to the north elevation. It has a fire alarm system as well as fully supervised system and is sprinklered. The bit of history on the building I will run through here. In July of 2022, the building was visited by enforcement inspector and seek the joint inspection of the commercial building inspector in regards to some work that was noted done without permits. That being a laundry facility that was constructed on the main floor in the lobby area of the building. And on August 15, 2022, a bylaw violation notice was issued to the owner of the building for the laundry room. Following the inspection on August 15th, 2022, later that day, the building inspector summarized what was discussed on site with the owner and sent an email of overview of takeaways. That's common practice, the inspectors do. Further, following on October 4th, 2022, the building owner made application for building permit. Said application remains in the system today, on hold, under review, has not been issued yet. Moving along to some correspondence back and forth over the year between June 20th, 2023, the building permit application was completed. That means it was completed vetting of the intake and forward off to the appropriate review bodies for review. December 7th, 2023, again, our building inspector was sent to the building for a report of a fire in Suite 105. Upon that inspection, it was noted that the fire repairs have been already done to that suite without the permits. So again, another bylaw violation notice was issued to the owner at that time. March 25th, as the permit application went on for the laundry room, the planning examination sent the owner a detailed requirements, what was to be submitted for that permit application for the laundry room to move the permit application along. On to July 17th of 2024, there was a group inspection. This was with the building owner, our bylaw enforcement officer, both mechanical and electrical inspectors with the building inspector, Manitoba Public Health Inspector, and Fire Department Inspector, and Community Bylaw Inspector, accompanied by WPS. This was where various life safety concerns were observed throughout the building and observed to be present. New laundry room remains at that time as it was. Again, permit was not issued yet for that. At the completion of the inspection, they advised the owner that in order to remediate all these deficiencies will be forthcoming. Winnipeg Fire Paramedic Service and Community Bylaw Enforcement Services were also advised the owner that orders from themselves to correct their issues might also be forthcoming. On August 13th, 2004, the building inspector issued another bylaw violation notice for the repairs taken in Suite 105 without permits. And finally, on October 7th, 2024, the document we are here to discuss today, the order was issued for mitigate unsafe condition and obtain permits with regards to all site observations done in that joint inspection on July 17th, 2024. So after July 17, 2024, there were other orders, again, as I mentioned before, issued by Community Bylaw and by Manitoba Public Health. There were also violation notices issued by the Fire Department. The orders by the other branches remain ongoing, as is ours. And here we are today at the appeal.
Questions? Councillor Shire.
Okay, a lot happened on this July 17th, which was my birthday, because the last appellant, I think, things were issued on July 17th as well. So busy day for the department. On this day, July 17th, we're here regarding that communication which took place on July 17th.
The order that was issued on October 7th, 2024 was I guess, a summary of all observations noted on that July 17th joint inspection.
Okay. So there's a joint, when you say a joint inspection, that was with whom?
That was all inspection disciplines within our commercial inspections group. That was with bylaw enforcement, had an officer as well, and community bylaw had representation there as well as the province had their inspector there as well.
And the province too, eh? Okay.
Yeah.
How often does an inspection take place like that?
Well, as the owner noted in a summary, they have annual inspections done, from what I understand, by the province, and fire do annual inspections at the property.
Okay. So they do have annual inspections from the province and from the fire department. In this case, what we call it, Fire and Paramedic Services?
Correct.
Okay. Fair enough. Do we have, regarding their annual inspections, do we have any communication with the province or from the cities, from the Winnipeg Fire and Paramedics regarding their inspections?
Actually, I don't have any copies of specifically of fire's violation notices that they issued. They did communicate to me that they did issue them.
Okay.
And they found compliance to them. So that means to me currently, I understand that they have nothing currently on the table outstanding.
Okay, so regarding annual inspections with both the City of Winnipeg Fire and Paramedic Services, there is nothing outstanding. There's been, they've been forthcoming in dealing with the inspection concerns by fire and paramedics? And you're not aware of anything from, are you aware of something from the province?
Yeah, the province does have their one order they issued back shortly after this inspection, July 25th. That order does remain outstanding, yet to be re-inspected and gain full compliance to.
Okay, and so the Manitoba inspection, there was one order for compliance, and that was dated when, sorry?
Well, there's 4 orders, I guess, on the table. Our order from Planned Property Development is the one October 7, 2024.
Okay, October, okay,
October 7, 2024.
October 7, and that's,
That was mitigate unsafe condition and obtain permits for the work without permit in the building.
I see. Okay, that's October 7th, 2024. Do we know about the ones from the province?
We know of them, yes.
Okay, do we know the date of those?
Yeah, one was July 18th, 2024, and the other one was December 16th, 2024.
So, okay, so July 18th, so 17th and 18th, a busy time for these things. What are the chances of that?
What are the province ones in regard to again?
Did you catch that, Councillor Edie, to piggyback, as Councillor Rollins would say, asking what they were about? Go ahead, Councillor Edie. I mean, to finish my question.
Well, sorry, but you asked about the dates and then you made a comment. I just want to get clarification. The inspections from the province of Manitoba are related to the furnace and that?
Yeah, the province had, there's a little bit of overlap amongst the 4 orders. Generally, it was building maintenance items. The province had some health concern items as well mixed in their order. But we're talking, like as an examples, fire separations not intact, cleaning up loose sharps, about not maintaining common area fire separations, doors that are not latching or missing hardware or missing door closers, stuff like that. Those kind of items kind of overlap amongst the 4 orders. It kind of shows up on all 4 orders.
And so there's been, over the years, because apparently they do get annual inspections from the province as well as the city, at least when it comes to fire and paramedics. Over these years, right now, we are dealing with one issue from anything from fire and paramedics in terms of things that have been going on for years there. There's no issues with fire and paramedics.
I don't have any record of that,
Okay,
no.
fair enough. And this came October 7th. What was the relevance of October 7th, sorry?
So October 7th was the summary of the deficiencies found in the large joint inspection on July 17th.
Okay.
And later in the order there, it notes itemized list of the observations that were taken during that day. As example, like existing fire separations, floor to floor, suite to suite, suite to corridor, incomplete. Fire rated closures and existing fire separations throughout the building have been modified or changed or damaged or missing. There was hot water tanks installed in the building's basement in the former boiler room area. Various fire separations in the basement area are not intact. These would be rated service rooms. Numerous openings and building services penetrations through the wall are evident. The boiler has been installed in an area adjacent to the existing former boiler room, so they relocated the boiler to a new room. New office constructed down in the basement. It mimics the new laundry room constructed on the main floor from previous inspection, and then some building alterations undertaken on the 2nd and 3rd floors to allow for additional rental rooms. Existing fire escapes have been barricaded and blocked off to prevent any access off them. Exit signage throughout the building.
That's a good thing?
That's a very bad thing.
It's bad to block them off. So what would you like in that case?
They need to be free, operable from the approach side without any restrictions. And they were observed to be chained and padlocked. Exit signs throughout the building have been altered or mixed between green Running Man exit signs and the traditional red ones. And then existing exterior window openings in the building have been altered. They've infilled some of the opening and put new windows in there and then filled the rest. All these work that I listed here. This all requires building permits, and we have yet to receive a building permit application to capture that scope of work.
What we're asking for is for the committee to uphold this order.
Speak up a bit more.
What we're asking for is for this order to be upheld today, and all the work that's listed here, to have all of that brought in under permits.
Are you ready to move on, or do you have further questions?
No, that's good for now, thank you.
Okay, we'll move on then.
I do have a question.
Judy?
Were there any permits pulled in the past related to any of this work that you're saying needs to be permitted, or?
In regards to this work we're talking about, no. We do have the one permit application for the laundry room that was applied for, but it's remained on hold since it has not been issued yet. It's pending further information to be submitted, and it's sat in its place since March of
23.
Okay.
2024.
Okay.
Yes.
And regarding the laundry room, it was stated there, mentioned that it's on the main floor. Is there something wrong with the laundry room being on the main floor?
Well, it's not to dispute, we're not disputing the location of that would get reviewed under the plan review. But it is a new room without a permit, constructed without a permit. It's got mechanical, electrical work that definitely requires a permit that was not taken out.
Okay.
And that work was completed.
All right.
Anything further? Okay, if not, we'll move on.
Hear from the appellant.
Yep.
Okay, so first we'll hear from the appellant, Isabeth Setti. That's right. You can come to the podium. You have up to 10 minutes for your presentation.
Hi. I hope everybody got a copy of the reply I filed to their allegations. I rebutted all eight observations they made in that reply. This hotel was originally constructed with 58 hotels as per city historical records. Right now, it only has 39 rooms. We did not add any rooms. We did not subtract any rooms. We have only 39 rooms, even though originally it was constructed with 58 rooms. It's part of the historical Manitoba Society archives. It opened in November 1905. New West Hotel featured 58 bedrooms, 3 parlors, reception room, hall, writing rooms, bar room, 40-foot bar, pool rooms, bowling alley, and barber shop. Rooms have not increased in my ownership. They've stayed the same as when I bought it. At some point in the history, it was reduced from 58 to 39 rooms. I do not have access to that knowledge. Hopefully, the city does. It is false to say that we did not apply for permits. It was my first experience owning a commercial building. I had owned commercial rooming houses before. I was under the impression that you cannot get a trade license if a building license or a permit is needed. We had asked the trades that installed the gas dryers and the trades that installed the electric washing machines, 3 of each. And they had issued permits, and the city did inspect the laundry before it was opened. This is what information the inspector has not provided you. The boiler room, the boiler, again, not installed in my ownership, but we have the owner here who did issue a permit, the owner of the hotel at the time the boiler room was installed. The hot water tanks talked about by the city were originally installed by Manitoba Hydro in that location, later over sold to the owners at that time. Again, the old owner will certify to that. The fire-rated closures are already covered under the fireman's order and have been complied with, and that order has been closed. Ditto for fire separations, again, falls under their purview and has been complied with. There is no office in the basement. It is secure excess beer storage area. They talk about a manager's residence. I have not heard of the manager's residence that in the 7 years I've owned it. I've talked to the previous owners going back 40 years, and we don't know what manager's residence the city is talking about. It is true that at the exit at the ground level, we have 6-foot-high gates to prevent people walking up the fire escape into the building. When we did not have those barricades, that exact spot was used for dealing drugs. It is for the safety of my residents that we had to put that barricade. If we had not put that barricade, it would be a much tougher law and order situation in that hotel than it is. It is still a tough situation, but that would make it much more tougher. What happened in the 2019 to 2021 COVID era was there were supply shortages. However, the existing fire emergency lights and signages had to be kept current every year. So in that process, because the red signs were not available at that time, a couple of green signs were installed and checked and verified by the fire department at that time. No opening, no exit window in any window is smaller than the original openings in the building. Picture of the original building from 1978 has been provided. Windows today are bigger than those windows. All 8 of the points asked for by this order have been addressed by me here. On addition, when inspectors from downtown come to our neighborhood, which is a little tougher than downtown here, we have to go into our building on a premise, which is what I do, that everybody in there is good. There is no bad person here. We have a share of people struggling to improve their lives despite disadvantage or disabilities and their struggles with addictions. This sometimes leads to someone destroying their room or breaking windows or ripping out copper from plumbing. This order would require additional commercial permits instead of trusting that the existing system work and are diligently maintained and regularly checked by the fire department. For example, last week we had a fire alarm triggered by a garbage can fire in a room, allegedly set on fire by a visitor who has a no trespassing order against her. So someone we have barred from a hotel came in, went upstairs, lit a garbage can of fire. The fire alarm started. We immediately searched for the source of the fire. The fire was diffused and controlled before the fire department even reached the premises. Next morning, fire inspector came to check and found that the fire panel was fully functional and fire extinguishers were refilled and ready. That is the kind of management we bring to the safety aspects of the building. 2 months ago, hotel guests living in room 112 purposely lit 2 fires. One in the fire escape hallway by their room, The first fire did not hold, but the one in the hallway held. The sprinkler system went off. Fire was extinguished by the sprinkler system before the firemen reached the site. The sprinkler firehead was replaced and the safety systems brought back online the same day. Any damaged wheels were also replaced the same day. So what the city is asking that whenever, and we have these occurrences, like I explained too in the last month, what the city is demanding is that every time there is such an occurrence, we go to the city for a permit, which take months. That is not how we can run a place in this neighborhood. We have to be proactive. We have to get the safety systems online the same day. We cannot risk what they are asking. The work has to be done the same day. We cannot afford to keep fire separations in disrepair. We cannot afford to keep the fire alarm not active and the sprinkler system not active. They have to be made active that day. That is why the existing system of the fire inspectors doing these inspections and coming in right the day of the incident is a much better system. All 8 observations have been rebutted. I request that this order not be accepted as it stands. As far as the laundry is concerned, because it's a safety issue, it has now been closed for 4 years, and I will take the required permits to dismantle the laundry. If the fire exit is also a concern that you do need access from downstairs, then I will redesign the fire exits so that they become the ones when you come down, the spring brings them down, instead of being attached permanently to the floor. I will do these 2 things so that this order is not required.
Okay, that's your time. Questions, Councillor Edie?
You're saying underneath the laundry room is beer storage?
Yeah, it's opposite the beer store.
So it's not an office?
The laundry room is not an office. Oh, the one in the
Below.
basement. Yeah, it's beer storage.
Beer storage?
Yeah, when we have excess.
Was that constructed at the same time as the laundry?
No, it probably predates it.
So there was never a permit pulled for that?
Oh, it's, so half the basement has, like the whole area is lockable, and inside are 2 rooms. One is our front office storage, one is our excess beer storage, and then the rest is also storage.
Okay. So was there a permit pulled for that?
The storage has been there forever.
Okay.
It's, I don't know, maybe in 1918, I don't know.
Right, okay. So, I know through the Office of the Fire Commissioner of the Province of Manitoba, there is opportunity to negotiate, like, how could I say, if you've got a workable solution to a code situation, it's somewhat different but not specified, you can get a ruling as to whether or not you could have that in place. Is that how that works, or? I'll ask that of the administration later as well. But. Do you know what I'm saying? Like,
Yeah, so.
it sounds like you're.
Yeah, so what happened is 7 years ago when I bought the hotel, on our first fire inspection, we were told that these ceilings, any ceiling tile that gets damaged has to be replaced by a 5/8 thick tile. We cannot use half-inch tile because they are fire separations. We accepted what they said as told and have continued to maintain it to that level.
Right. Okay. So, well, actually, so the fire escapes are blocked, And I totally get what you're talking about in terms of the safety of people who are living in the place and people who might try to circumvent things by going through the fire escape. But like, what is your plan if you got that blocked off, what's your plan in a fire? How are the people getting out
Oh,
if you got it
that's
blocked?
blocked
if you
off
got it
at
blocked
the
off?
ground level. At the ground level. 6 foot is a safe jumping height.
So you got, I'm sorry, oh, it's 6 feet high?
Yeah, 6 feet high at the gate level, at the ground level.
Okay.
It's some things you can jump off safely. It's
Hang
not,
and jump, yeah. Seems to me, I remember a fire escape at another building on Main Street when I was young. It had like a foldable, like as soon as you put some weight on it, it would go down right to the ground and you could walk down those stairs.
yeah, my son showed me something like that, and we would be willing to move to that if it is required by the committee.
Right? Like, yeah. So it's high enough up where somebody from the ground can't pull it down, but when you're coming down from the upper floors, it just releases and goes down. Okay. Geez. Well, I'm going to ask the administration, but so you're saying there's some issues, they've got issues with the window space? Actually,
That's in the report, yeah.
pardon me?
That's in the report. That's one of the items.
It's not an item, right?
Yeah, it is.
So is it your understanding that the size of the windows and that are grandfathered because of the age of the building?
Yeah, because they are not egress windows to start with.
Okay.
There's a fire exit plan posted on every floor. In case of a fire, which way are you to exit the building?
Right.
So those fire exit plans are on every floor. Windows are not part of a fire exit plan.
Okay.
They're not in the fire exit plan, and they're not part of the fire exit plan.
Okay. Okay. I can't think of any other questions at this point.
I have some questions of him. Councillor Arshad, do you have questions?
Sure. At this point, what are the costs of the fines at this moment?
There's no fines.
There's no fines at this point. We're looking at compliance over a number of issues. Have they stated to you at this point, at what point do fines come into it? Do they tell you how many months you have before there's fines or anything like that?
No, there's no fine attached to the order.
Okay.
This order has been added to the title of our property. They're not putting a fine. They're mortgaging the whole property.
Okay, thank you. Now, in terms of adding this to the title, you mentioned something like, rather important, you made the point you couldn't wait for your fire system because you can't go days or weeks without one. So you said it was repaired right away. You said when there was a fire? You
Yes,
said you can't wait for the city. You need to have it operational.
it's a building that's being lived in. We can't compromise on safety.
I understand. All right, so that's regarding your sprinklers.
Yes.
Yeah, okay. And in terms of the fire escape, it says you're saying it's closed at the first level. And you're saying it's safe to jump from 6 feet. Can you explain that? I mean, you talked a little bit about that. I'm not sure how that works.
The inspectors can tell you that the Manitoba Code allows an escape jump off at 7 feet.
Okay. Really? 7-foot jump off. All right, well, they can explain that. I don't know anything about that. That's why I'm asking. 7-foot jump off. I wasn't aware of that. And you're saying in this case it's 6 feet.
That's right.
Okay. All right. Numerous other points to this. And I guess I'll leave it at that for now. Chair Rollins?
Actually, I thought of some questions.
Did you want to go first, or?
Yeah, I just wanted to ask about, so you said that the Manitoba Historical Society or something has a write-up on the New West Hotel, but is the New West Hotel, is it a heritage building?
Yes.
It has that designation, and whatever you do there, you have to meet.
I have the printout here.
So on that printout, it designates certain things that are features that if you're doing renovations or whatever, you have to upkeep.
Yeah, it notes that historical sites of Manitoba, it's part of the historical sites.
So it's not part of the City of Winnipeg
Heritage building, yeah. Just a historical site,
It's historical designation, but not,
heritage designation.
not a
Doesn't have the
heritage site,
heritage.
yep. All right, good to know.
So it's, it's somewhat, it's not always rare, but it is somewhat rare to have an order to remediate deficiencies and mitigate unsafe conditions, where the owner says, on the one hand, the unsafe conditions, I have a fundamental different viewpoint of what safety means for my neighborhood and my building. And on the other hand, I'm not going to get permits because, and my question is this a fair summary? I'm not going to get permits because in your respectful position, time is of the essence, and you need to continue constructing.
No. I'm not saying I'm not going to get permits. I'm saying permit requirement for something like this should be a little higher. It should not be, because we have these incidents monthly.
What should be higher, sorry?
The standard to ask for a permit should be higher. If there is structural damage, ask for a permit. If somebody punched a hole in the wall, do not ask for a permit. That is what I'm saying.
No kidding, right?
So, and then you mentioned you've addressed all 8 items. I see 12 items on the agenda here. But maybe you're grouping them slightly different than the administrative report before me. So with respect to, for instance, the last item, the existing exterior windows, you know, the department's viewpoint is that you need to do something about the framing and sheathing to accommodate these new smaller windows. And you say, I agree, they're different size.
I agree there's different size because we went to casement window, which makes it a bigger opening, not a smaller opening.
And
When you go from a slider to one
Yeah.
single pane, then it gets bigger, not smaller.
Yeah, you generally agree. And then
But they
on the-
want me to do a permit for it now.
Right. And on the exit signage through the building that have been altered, you say, sure, you agree, they are different. And
Yeah,
the
and it
supply
happened
problems we
during
described.
COVID. It's been inspected 3 times by the fire department.
And then on existing fire escapes that have been barricaded and blocked off from any access, you said, yeah, they are, because I've got a security issue, another type of security.
But I'm also saying that I will, if needed, replace those to a system where there's no
Yeah, I
access.
heard you. I'm just, so the former building manager residence suite converted to rental rooms. So you have a whole bunch of inspectors there. It's a combined inspection with Manitoba Health, a variety of Winnipeg departments, and Winnipeg Police. And you say you still don't know what the converted rental room means at this juncture?
There is no manager's suite is what I'm saying.
Okay.
I'm not saying there's no rental rooms. There's no manager's suite in the hotel.
So the conversion of the rental rooms, do you also dispute that, of whatever that resident suite was downstairs?
Okay, I don't dispute it because I've never seen it, I dispute it, but I have owners here going back 40 years, nobody's seen it.
Okay, so is it the case that you don't know what it means, or,
There is no manager's suite in the hotel.
okay. And then in
There
terms
is
of
none,
building alterations undertaken on the second and third floor,
none. One extra doorway put in, inspected by the city bylaw, because room number 200 had only one exit. There's no window in it, and an additional door was installed. The bylaw officers at that time checked it and said, okay.
and now you understand them to say what?
So that's what I'm asking, like what construction on the second floor? That's the only construction on the third floor done, an additional doorway added to an existing room. So from one door, it got two doors.
Okay, I'm going to ask the same questions of the administration, because there's like a lot of divide in terms of just basic understanding of what's in front of us, given that, so, and in terms of existing, I'll just ask one more. The new walls constructed in the areas adjacent to the boiler room, you think that that issue pertains to the previous owner? And you
No,
brought him here
no, absolutely not.
to discuss the boiler?
The walls by the boiler room were constructed at the instructions of the fire marshal. They were not something we dreamt of. This was something conveyed to us, it has to be done. So it was done.
Received an order from the fire marshal to build those walls?
Yeah, so that is the issue, right? On one side, one arm of the city comes and tells us during our annual visits that this needs to be done. And we said, no, like it costs a lot of money to do it. He wanted a fire door, fire-rated drywall. But he said, no, it needs to be done. He was talking on the phone to someone. He made us do it. We did it. But now city says we need a permit for it. City made us do it.
With respect to permits, when the city, I mean, the city is also pointing to professionals in this order. The city has a variety of arms, as does the province.
Absolutely. I respect professionals. I am a professional
Have
engineer.
you gone to the city website to see when a permit is required? Because do you think that when the city says you must do something, then that doesn't mean you need to get a permit? And then you need to call the permits office to get the work inspected?
I understand your question.
Okay, good.
Fire marshal says something, we
Yeah.
do not question. Okay, it's a safety issue. If he tells me this needs to be done, I do it. I do it. I do not deny it, not.
Sure.
If I want to postpone it 6 months, sure. I'll go apply for the permit. But he needs it done yesterday.
Okay, so is that a yes or a no? Do you apply for the permit or no?
I did apply for the laundry permit.
One permit out of these long list of items, right?
No, the laundry permit was applied in 2017, which the gentleman has forgotten to mention. 2018,
there's
when the
two
laundry was
laundry rooms now.
actually installed.
There's two laundry rooms now.
No, the same laundry,
The new laundry room constructed in the main floor block.
2018.
That one?
2018,
Okay.
trade permits were done. Trade permits were done. They can confirm.
Okay. That's my questions.
The inspectors came, inspected it. They made us do a few changes on the glass. They wanted metal added where the vent, that is vented outside. It was done at the inspector's order when they came to close the permit. Those permits were done. But after looking at the specs on laundry rooms, I have shut the laundry room. It's not in use, and it will be dismantled. Because as an engineer, I understand the safety issue with where it is. So I will dismantle it.
Okay.
Probably
Anything
have to
further?
do that under permit too.
Any
Can
further
I ask a
questions?
question?
Yeah,
Just-
go ahead.
So, did you know there's provincial legislation that states, like, even if you're ordered by the Office of the Fire Commissioner, that all permits are run through the city regarding anything you're doing to a building? Like, within the city of Winnipeg? Did you know that?
Yes.
So if the fire marshal says, well, this has to be done, you still have to pull a permit with the authority body, which is the city of Winnipeg, right?
That is right. Only thing is, in this case, we were new at owning the hotels. First fire marshal inspection, he asked us to get it done. We got it done.
Okay.
Right.
I get it. And, well, I'll confirm with the administration about putting your sprinkler system back into order. Are you supposed to pull a permit for that?
I have no idea.
Okay. All right.
Okay. Any further questions? Okay, we'll go to questions for the administration unless someone else is registered to speak.
We have no one else registered to speak, but is there someone else wishing to speak in support of the appeal or in opposition?
Anybody?
If you wish to speak and you're not registered.
My name is Tony
Just-
Banshee.
We'll just quickly get you registered and then you can speak and
Okay.
have 10 minutes.
All right.
Tony's just signing in. He didn't register. He hadn't registered yet, right?
Okay, so you're going to speak in support or for information on the appeal? In
Yes.
support of the appeal, okay? Go ahead, you have 10 minutes with committee.
About the boiler?
You can speak and design your 10 minutes however you
Okay.
want in support.
What it is that in 2006, the inspector of mechanical engineering came and said that our brick boiler was to be condemned and we should get a new boiler put in, which the licensed engineers of the city or the government body that came and checked it and ask us to put another chimney liner outside temporarily for 1-2 months till we get a new boiler installed. We got a new boiler installed. All the inspectors came and checked it, gave us written permission and all the certificates, which I think the city misplaced them. I'm not going to say they lost it, they misplaced it, which they can't find them now, and they want him to get new ones now. But we had all the permits in year 2006. Every year, the boiler gets inspected, the inspectors come in, they check the hot water tank room, they go through the whole basement, check the fire inspectors come and check, and everybody checks it. And why it just comes up right now? Because of lost records.
No, okay, okay.
The hydro-powered hot water tanks are owned by Manitoba Hydro at that time. Maybe 50 years ago, they installed them, and they are installed by them at the right place next to the furnace room. That was the old boiler where it was. and then we had to move the boiler somewhere else, which they advised us to put it there, the boiler with the sketch and everything. Also, we put a concrete new pad underneath it due to the weight of the boiler.
Okay. Anything further? Anything further?
No, basically further is that's what he called me to come in, and I was the owner for 23 years since 1987 till 2009 and 2006 when we put a new boiler in with proper permits and everything. We don't have the records now because we sold the hotel in 2009 and then it got resold again, and it's still the same boiler. Everything is the same downstairs. And if there is something old, that does come under, law of that, it's there from when the hotel was built. Grandfather clauses. If you start changing them now, you will damage the building by cutting some holes or moving some brick wall. Then there's another code involved to do certain things. So it was a lot of work is kind of grandfathered. That's the way it is. But these new boiler we put in, that was only done in 2009. Sorry, it's 2006. That's it. If anything else, you can ask. All the rooms, yeah, one more thing. The rooms are same. There never was a manager suite in that, If it was a manager suite, I would have been living there as a manager. There was never a manager suite. It's all rooms. We were out to make rent out of the rooms.
Okay. You have questions?
Where did the management work from? I know in the Northern Hotel, the manager works in an office when you walk in the front door.
Yeah, by the bar, there's a small office there. That's where we have our safe and all our monitoring cameras in there, and it's right behind the bar.
Right, and that's where the manager works on it?
That's where the manager, the boss, say we sit, do all our work out of there. It's a small room, maybe 8 by 8 feet.
No, I'm just want to know, so that the manager doesn't live in the hotel, right?
No,
Okay,
there never was a manager.
okay, wow,
To live in, there was a manager, but not a manager suite.
right, okay.
Yeah. That's it?
Okay. Thank you for your time today.
Okay.
Any questions for the administration? Councillor Schreier.
Sure. In terms of, there's a few things here. One is the issue of the fire escape was mentioned that was blocked off. The point was made by the appellant that that was just for the bottom floor, and a 7 foot height is legal, and this is six feet. I didn't know about this. Is there anything you can tell me about 6 and 7 feet when it comes to fire escapes and heights?
The fire escape requirements for this building require to exit at grade. So the fire escape shall extend down to grade level outside.
Can't quite hear you, sorry.
He says it's an exiting at grade.
The fire escape diffuses at grade. The fire escape requirements for this building requires it to terminate at grade.
And so how is the distinction made in terms of, I understand what you said, the fire escape shall, what's the term you used? Shall do what at grade?
Yeah, the exit for fire escape requirements for this type of building, it shall terminate at grade. It shall exit
Sure,
at
it'll
grade.
terminate at grade. Okay, fair enough. And just so I have some context to this and some understanding, how does it apply, this 7 foot maximum? You're allowed up to 7 feet from the ground for there to be a legal fire escape. Do you know how that works?
That might be another type of building, but for this type of building, it requires it to exit and terminate at grade.
Okay. And regarding the boiler, just given what they said about the boiler, 2006, we don't have records from, do we have any records from anybody on, regarding the boiler from 2006?
For the boiler, no, we don't. We have building permit records. We have one building permit record from 1968. It's a record that sheds light on this manager suite issue that we're talking about earlier. We have another building permit record from 2006, which was a main floor beverage room renovation. Again, nothing referenced for the boiler room. So when we're talking about the outstanding work done without permits, it's the laundry room constructed, which we have, like I said, have that permit application in the system, just not issued yet. We have the new boiler, the new service room in the basement, adjacent to the existing boiler room. We have that room constructed without a permit. And then we have the, it was observed as an office space because at time of inspection, you walk into the room and had a desk and chairs for people to sit at a desk. So we referred to it as an office. There was no evidence of anything being stored in there, like beer storage, as the example was mentioned. That wasn't observed. So if that's the use, okay, but it's still a new room constructed without permit. So those 3 rooms constructed without permit there's no permit records for any of that.
All right, and in terms of the room that you speak of a room that the appellants, or at least our primary appellant here, made the point, it's not a new room. It's beer storage has been like that for over 100 years. What do we say about that?
Well, the unfortunate part of any property owner that acquires a property, along with the property, they acquire any work done in the past without permits. There's a point in our order that does speak to that point. It's touched on top of page 2, section 5.4.2 in the Winnipeg Building Bylaw. So if you buy a property that has outstanding work that was completed in the past without permits, the current owner is responsible for the permits that are required for that work that took place, which is the case, maybe the case here.
Okay. You said maybe the case here?
Well, sorry, I misspoke. It would be the case here because we do not have permit records for the rooms that we're talking about today.
Okay. And in the sense, yeah, I mean, I understand, I have to say that the issue of how to define an office, I mean, if there's a table with a couple of chairs, I've got them all over my house. Every room in my house has a table and chairs. Pretty much could make the argument every room in my house has got a table and chairs. Yeah. And in that respect, what constitutes an office? What constitutes a sitting space? I don't know what to say about that. Can that happen that there's disagreement as to what constitutes an office under circumstances like this? I have to admit, I haven't seen the photos. I'm just going by the fact that I've got, yeah, every room in my house has got a table with chairs. Wouldn't call them all offices, but yeah, if you have any comment on that.
The room was, like I said, is observed with a desk and a couple chairs. It was referred to as an office. If they're referring to it as a additional beer storage, because they do have an established beer storage room down there back from 1968, it shows that this new room, whether it's an office or additional beer storage room, is nonetheless still a new room constructed without permits. Okay. So whether we talk about it as an office or a beer storage room, it's still a room in a new use introduced to the basement that was originally all storage space. Everything in that basement was storage space with exception of a couple service rooms. Okay. It was nonetheless a new room established or constructed without a building permit.
And our appellant has been making the case that there's been numerous inspections by fire and paramedics or fire with the province as well over the decades, and to what extent does their satisfaction affect, I guess, the conversation we're having today? I mean, I understand we put this forth anyway, despite the annually or regularly the police and fire and paramedic services doing their independent annual inspections. How do what does the province have to say about these issues regarding an office, whether it's an office or whether it's a table, or the issue of the boiler or the sprinklers, things like that?
The province's material in their order wasn't for these new rooms constructed without permit. That belongs under our order. Theirs spoke to more the livability and the public health concerns throughout the building.
I didn't quite hear that answer, sorry.
I said the province's order that they issued was more livability concerns and health concerns throughout the building that they observed. Our order is specifically the order that talks about these rooms constructed without a building permit, because that's under the Winnipeg Building Bylaw.
The appellant made a point which I certainly sympathize with, especially given the nature of the building itself. And that is, he's talked about when there's an incident where the functioning sprinkler system had to be used. So it was used. The fire department came in, they did their business and said that things have to be done to the sprinkler system. They didn't wait, as they explained it, for the purposes of safety. Now, I happen to believe that. They did what they had to do, and they didn't wait, making it, in that respect, making it safer. And what kind of, this must happen, this gray area in which we want these things to be adhered to. Thus, we have codes for these things. We have a department, we have an office to make sure that these things are adhered to, and in some sort of timeline. In this case, they jumped the timeline saying it goes against the spirit of why we have sprinkler systems. Why do we have sprinkler systems if you have to wait for a permit? And therefore, they jumped the gun.
I think he understands the question.
Yeah, fair enough.
Can you respond?
Actually, I don't quite understand the question, to be honest.
I guess he's asking about our processes relative to the urgency and need. Is that fair?
Yeah, I'm saying they're making the point, it wouldn't be safe if we had waited. It's safe at this moment because we
And he's
fixed it
asking you to
right away.
comment.
Well, if a permit is required for whatever type of work it is, whether it's to repair something that's not working, any of the affected areas, if it was a significant enough life safety issue, then they shouldn't be occupied until that is repaired. But I don't think that that's what necessarily is the case here. I think fire will come in and they will issue their orders, which we really shouldn't be speaking to with regard to life safety concerns. And so if something is requiring a permit that is directed by another department or another agency, the onus falls under the building bylaw. The onus falls on the owner to obtain that permit.
Can I get in on a question? Can you comment on the opportunities for education for compliance when it was a group effort in July? Was, for instance, the owner present? There seems to be a lot of, difference, like a whole other legal framework that the owners have in mind. For instance, when you date back to 2006 or 1978, we've had a whole new code, since then. So can you speak at all to what that tour was like if the owners were present, and if there has been an engagement on the basic understanding of, codes, regulations, bylaws, and what you mean that is clearly spelled out in the order, right? By compliance, what you mean by, with materials suitable and sufficient for the purpose, what you mean by, a building permit issued with respect to the building. Were there opportunities for education for compliance? Because there's a bit of a divide in this room right now.
Yeah, of course. Well, the owner was present for all inspections done by our staff and the other departments we mentioned earlier. He was present for all those inspections. It was, as always, it's explained by, I can speak on behalf of the building inspector, that's my group. It is explained in detail, and it's usually followed up with an email, like takeaways. And the building inspector's name and address, phone numbers noted on the violation notice, so if there's any questions, you call that person, get in touch with the building inspector for further explanation. It was also asked by the owner to retain design professional to help articulate the scope of work required to bring this building back up to compliance. That was a kind of a big part of the ask, which would be quite significant and to his benefit in the long term to get the permits applied for and issued, and bring him clarity on any misunderstanding that might be kind of ongoing and not quite reaching its,
Yeah, arrival.
Yeah.
Okay. That's all my questions. Councillor Edie.
Okay, I'm getting the gist of this. Just one question. So there's an assertion that permits and somehow you buy a place and you're supposed to keep the paperwork or
We're
whatever.
still on questions for the administration. Sorry, Councillor Edie. So you can sit back down and I'll call you up for a rebuttal when it's time, okay?
So,
And only one gets.
yeah, so if I talk to your property and development and I insist, like there was a permit pulled and you may not have the record, but I just heard that it sounds like I think it's the Office of the Fire Commissioner who handles the boiler thing, and somebody came in and inspected that boiler and said it had to be replaced. Is the city able to check with the province to see if they got a record on that? Or is that onus on the owner of the property to try to find that record?
well, ultimately, it is, responsibility is under the building owner to do all that. Does the city communicate with the province? Yeah, perhaps, if required. But if the owner's seeking clarity or conclusion to anything asked upon him by the province since the get-go, the onus is upon the owner to ensure that gets carried through.
Does the department keep files of stuff besides just the permit related to applications? Like whoever, if there was an application, somebody worked on it, do we keep those records from like 2006? I'm sure there's a lot of different people working in permits now and stuff. Do we keep any kind of files on that?
We have a permit archive resource that we use for the older stuff. The electronic files, we do have access to fairly immediately.
That's after what year? Sorry.
2005,
2005, okay.
2003. So that record there, there's no record of building permits
Nothing at all.
for this work, no.
Yeah, nothing.
Sorry, applications, building permit applications for this work, aside from the laundry room that we talked about earlier.
Yeah,
That
Madam
permit file is on record.
Sorry, Madam Chair, through you, we also only will keep completed applications. If an application is not a complete application, we're not going to keep that.
You wouldn't keep an incomplete?
We get far too many of those every year where people
Okay.
change their minds or just don't follow through. And that would take up some precious storage room.
Right, okay. Well, anyway, so what again is your problem with the boiler? It's just there was no permit pulled, right?
Yeah, like, there's obviously been some discussions with the fire, the owner refers to them as the fire inspector. That's likely Winnipeg Fire Department inspector, and/or might even be the province. And somebody flagged it and gave the heads up saying, hey, this equipment has to be in a fire-rated room. Okay, fine, let's do a fire-rated room. And the questions and answers were probably delivered, saying this is what you need.
And you have to
However,
pull a
no building
permit
permit
for
was applied for it, that's all. That's the missing piece.
And you'd have to pull a permit for that, right? 'Cause-
Yeah.
Yeah, with the city. because I think I was right in stating, like when you're working on a building, the permits are pulled through the city for the most part, and then if you need a health permit, you refer people to, for example, for a restaurant, you'll refer to the province's health inspection crew, right? Licensing or whatever? Is that right?
Sorry, I didn't know if that was a question.
I'm trying to use an example. So if I'm doing a restaurant, there's building permits and stuff, but then there's health-related inspection or licensing from the province, right? In that regard?
Right, it gets circulated to the
And
different
you would
departments.
refer them to that, right? That's,
As part of the process for the permit application, yes, it automatically goes those ways.
yeah. But it all starts with when you have to pull a permit. Okay.
Right.
Are you ready for rebuttal, or do you have further questions?
I'm almost ready. There was one other clarification. Oh,
We could have been out of here at 1.
so how can you tell, you're saying there's this new room downstairs? Is it like today's gyprock is installed there, or how, or did they just change the use of a room?
Again, we go back to the last records we have on the building layouts, which was provided in the 4304 file for the building. That was issued in 2018, so we do have a 2018 layout plan of this building, all floors, what it should look like, and where the rooms are and what the rooms are where. We also have to cross-reference the last permit we have on file that shows every floor layout. That's the 1968 building permit. So we have those rooms there, which shows the basement in its layout, which all storage rooms, and a couple service rooms. This room was just an open storage area where they constructed the service room, where the new boiler went. So that confirmed to us that was not put there under a building permit. We would have a
So
record
it
of that.
created a new room, okay.
So in comparison to the existing files we have on record, for the drawings we have on record, it tells itself that it's not there under permit.
Right. But if it was an existing so-called room and the use was changed, you don't need to pull a permit for that.
It might have been an existing room in 2017 when the owner bought the building, yes, but not, it's new room from the last records we have under permit for the building.
If I change the purpose of a room in my house from a bedroom to an office, I don't have to pull a permit for that, do I?
We're talking hypothetical, but bedroom and office are two totally
I don't
different
think
things,
so.
yeah.
Anyway, all right, thanks.
Okay. So we're ready for you to come back and speak in rebuttal. As you are the only appellant, you're the only one that's allowed to speak in rebuttal. Okay? You have 10 minutes, and you can direct your comments to me.
Mr. Cameron,
Chair.
did you find
No, I'm
out-
sorry, sir, you don't understand. I'll explain. You have to direct your comments to me, okay?
I
And
had
you're allowed to rebut to the
asserted,
committee.
I had asserted,
Yeah.
it's not been answered by the administration, that there were trade permits for the laundry room. They should be in their records, they have not recognized it.
Is that all you want to say? You have 10 minutes with us.
No, that was one point.
Okay.
Anything that they are asserting is not in a permit, I will dismantle. I do not need boiler walls required by the city built. Okay, if they don't want it, I'll dismantle it. The room they're saying is an office, is not an office. If they want me to take it down, I'll take it down. It's just storage. I don't care about storage in the basement. I have a bigger door, I have to store beer, I'll just close the bigger door then. It's not something I want to spend resources on. To hire 3 trade engineers is tens of thousands of dollars. It makes running a hotel unviable. We'll have to look alternate uses for that building. Why should we be running a hotel where a punch in the wall needs a permit? And there is a punch in the wall every day.
I don't know if he's finished, Counselor Edie.
He's in rebuttal, but I forgot to ask administration a
Well,
very
you
important
have that
question.
opportunity after he's done, because he's in order. Right?
So
He's gonna finish his
anything
8
that the
minutes.
city thinks we need a permit on, we will dismantle. We won't keep it.
Is there anything more you want to say? You have 8 minutes.
Uh,
You'll have another opportunity. Counselor Edie has a question.
Okay.
Okay?
The fire exit with the descending that the councillor suggested, we will do the permits to bring it to that, because that's the need of the hour for the building. The laundry, we will dismantle, we will do the permits to dismantle it. Any other thing they think we need a permit for, we will dismantle so that we don't have to go through that process. We will take the dismantling permit. What has happened is we have a lot of drug usage and drug pandemic in that part of the city. It is making this business very, very hard to run. An overburden of regulation that is coming from the city with duplication and triplication of effort will make this business unviable. I do have alternate uses for the building that I can use it. I do not have to use it as a hotel. I have other businesses. 18,000 square foot of storage is great for my businesses. If you make the business so expensive to run that it loses money because of these actions, it becomes an unviable opportunity for an investor. We want to work with the city for the housing of the needy, but we cannot do it if our hands are tied. We cannot do it if our hands are tied. That is all.
Okay, Counselor Edie, questions for the administration?
And actually, just for this
Okay.
gentleman, just on the whole boiler and the firewalls or whatever, all the city is saying is there was no permit pulled. It probably meets spec, as you said, because you talked to the province about it. What's the problem with pulling a permit after the fact? I mean, it's dealt with.
I don't
What
mind
would be your
pulling-
problem?
No, there's no problem with pulling a safety permit.
Or-
If they want me to pull a permit for that, I will, but they want all three services. They want the building to be brought to today's code. I am
Yeah,
not
no, I
willing to do that.
I understand. Okay.
They want all three engineering reports, not just one. All three engineering reports are required, which brings it to today's code. I cannot do that. It makes it an unviable project.
Well, the boiler has to be to today's code, right?
The boiler room
You don't
permit,
want something blowing up your building, right?
the boiler is inspected every year, sir.
No, I understand that.
Yeah, and the boiler room is right now a fire room.
Yeah, okay, all right.
Yeah.
I just asked that question. Now I'm going to ask the administration one question. The administration asserts that the type of, your building is not the type of building where you could have a 7-foot, up to a 7-foot drop. So I'm just asking the administration if it would be considered at grade if there's it's kind of a levered fire escape where as the people trying to escape the building, the fire, the stair goes down and it lands at grade and people get off the stairs at grade. Does that meet code?
That example would be one of a past design that we do see in older buildings. I am not aware of any current code that would allow that. Those sorts of determinations would be made at the plan examination level. That's looking at the building permit application for that school
Does
board.
put you at grade, but you understand the safety risk of having something at grade that somebody's going to go up there and maybe break in and shoot somebody for that matter in this particular neighborhood. That could happen every day, right?
I understand that, but unfortunately, the building code does not address those sorts of matters.
So it just says the fire escape needs to end at grade.
The purpose of that fire escape and the function of that fire escape is to bring occupants of the building on from whatever floor they're on safely to grade level to escape the damage inside the building,
Okay.
the danger.
All right. Okay, I just wanted to ask that, so. I would say that fire escape is taking me to grade, so.
Okay, so they have another chance to rebut unless there's other questions for the administration at this time?
Well, I still had a question for the appellant.
Okay, but if you can finish your questions to administration so that they can rebut.
Well, I'm finished with my question. I just
So-
forgot to get clarification.
Counselor Schreier, if you have anything for the administration, we'll go then to them to rebut.
Yeah, I don't have any questions for the.
You're allowed to ask a question, and then they don't have to rebut again on their own. And it's just the one appellant. Okay, go ahead, your question.
Sure,
then,
thank you.
Counselor
You
Schreier.
mentioned the point, you said that they are requesting all three, didn't quite catch what you're saying, all three departments? You're saying,
Reports, their order says,
all three reports.
so they want mechanical design professional, building design professional, electrical design professional, mechanical, all three, to do a complete analysis of the building and issue permits. That is what they're asking for. They're not asking for a permit for that. They're asking for the whole building, complete analysis, which brings it to today's code. Which brings it to today's codes,
That's right.
which will kill the business.
Anything further, counselors? And then he can rebut on what he's heard?
I don't know what
Anything further?
to say. It sounds like the building isn't grandfathered, so
Okay, so,
I have a concern about that.
okay, so you have another time to rebut anything you've put on the record or we've talked about, if you want another opportunity to rebut. That's our process here. In rebuttal, you don't have to, but you're allowed to comment on the last round of questioning with the public service. You don't have to, but you can.
I don't have anything else.
Okay. All right, so we'll move into motions then. If you want, you could take the chair, Councillor Edie, and
I would take the chair.
I can do the motion if you'd like.
I really don't know where to go on this,
Okay,
because I have to say
we'll throw a motion and
I'm
let's,
kind of hearing the owner of this building, and if this is how it's going to go, I don't see us saving any buildings down Main Street that are that old. Anyway,
okay,
all right,
so we'll just get to the, I
I'll
move,
take the chair.
yeah, you'll take the chair? All right. I will move the receipt of public representations be concluded.
All those in favor?
Aye.
Nobody's opposed, that's carried.
I move that the appeal be denied and the order of the Chief Commercial Building Inspector, Development Inspections Division, Planning, Property and Development be confirmed, and I have a rationale, Mr. Chair.
Okay, please, so you're denying the appeal, and for what reasons?
Okay. So I think it's very important to acknowledge that several times we have heard a basic economic argument at the podium from the appellant, Mr. Chair, with respect to the affordability concerns. I also really want to acknowledge that while unfortunately it's become common, just how many public service resources, regulatory inspectors, those involved, we heard in the province, while not before us today, came together to look at this building in July. And in some cases, us as councillors know all too well some of the risks and some of the things that not only the city of Winnipeg, but the province has to reconcile when there are downtown hotels that provide real subsistence housing, but also has very subsistent troubles with respect to life safety concerns. So taking together that this, what is before us is an order to mitigate unsafe condition and obtain permits, I want to underline that and support it because those living, and it's difficult to be a counselor who has supported, for instance, a vacating of the most unsafe housing encampments, but sometimes when there were repeated fires next to a hydro pole, like there was close to the property that, you know, now a Mwegamig sits on, it's not safe, people might die. The same thing with hotels. And we know that the property next door certainly caught fire. We also know that our own firefighters really risk themselves, and we just had a firefighter fall through a floor over the holidays. When there are repeated fires, let alone safety concerns, and there are people living in the building. And so while I always have, as every counselor along in this committee does, the tension between providing housing and life safety, I'm really going to assert that where there are unsafe conditions and where we need to obtain permits, and that there has been almost a whole of government response, that we're doing all that we can to underline the importance of the life safety options that are before us today. We don't have fire before us today. We don't have any of the provincial health orders. What we do have is a list of unsafe conditions and that are known fire concerns, that are known life safety concerns, and we have the opportunity to underline it today. What I found really troubling is that we know that the city wanted and issued this order for work done in November. We are now in January. And at no time did I hear the appellant say that he'd engage in work in line with the spirit of this order. I heard a series of sort of half measures, that it could be something that they found online that still wouldn't be compliant. That divide is what I find really troubling and why I'm not finding in favor of the appellant. Moreover, when, you know, there is arguments forward from 1978 building code, and I think that's a fair characterization. I'm concerned about, you know, the knowledge of and the care and concern of owning a building with tenants in it in 2025. So for all those reasons taken together, I can't move a motion that even in part, you know, doesn't underline the unsafe conditions that are there, the need to obtain permits, and those are my supportive comments.
Okay. Thank you, Councillor Rollins. Councillor Schreier, did you want to?
Yeah, I've got a dilemma here. In fact, I'm not sure if I should have voted that the receipt of public representation would be concluded. I'm not sure. We're caught in a dilemma. Almost, this is like we're at a crossroads at this point, and it was expressed as well in the other applicants and the other appeals that we had today. Who are we to deny the reality of cost affecting our society? And in this case, we have an owner, the third owner. We have the first, of the last three owners, we've got the first and the third owners here. And this building has been running for decades. This building has had annual inspections by the province as well as by the city's own fire and paramedic services. There's a discrepancy as to what needs and does not need to have a permit. That's one thing. Also, the issue of cost. My concern here is given that this people that own this building have been going through annual inspections, apparently every single year, with the province and the city. I'm not denying the issue and the need for building codes and adherence and development permits. I'm not denying that. And this is my dilemma here, because I'm looking at allowed in part. I believe the owners have shown essentially good faith with the levels of government that have had obligations to deal with them. They've done that every single year. And at some form of compliance, they've made the strong case, they made the strong statement, not the only ones today, that cost is being prohibitive. And what do we do with a building like this? I'm not denying the need for building codes and for building permits. My point is, as being stated today, how do we do this in a way that is beneficial to the intent of why we have city government, governance, codes, and building bylaws and building permits and building permit bylaws. My concern is for this owner now, the owner at this moment, after all that's been said and done over the last few decades, if not longer, it's now incumbent upon this owner. Of course, it's got to be incumbent upon somebody. We understand this is not being grandfathered. My concern is this: time. How much time do they get? Time is money, and the less time you have, the more money that is at any one point. And in that respect, it's sort of reversed. You put this all on the owner of this building now, and what are we saying in terms of the valuability? My case I'm going to make here is for time. I do not know how to put that into this motion. That is my dilemma. Can we add it? I don't know what to say, but that's really what it comes down to me. Given all they have been doing over years, all of a sudden, it's all happening at once. And
What time do you mean?
that's a good point. What time is there to adhere to these permits? That is the question for me.
Do you mean with respect to the direction in here that says, for instance, because there is an indication of a timeline by the public service. I mean, we've passed some of the November dates, but here it says, once it has some timing, but it says obtain all the required permits no later than January 13th, 2025. We've blown past those dates. So there would be a re-engagement. Is that what you mean?
Yes, but questioning whether we count the number of weeks on our hands is going to be the timeline. That is my concern. I understand that, when it comes to code and bylaws, there should be a timeline. I get it. In this case, we have to admit, we have to accept the fact that as a society, as a city, we do grandfathering, we do longer-term timelines in terms of refurbishments of buildings. All of a sudden, a building gets refurbished, but the building may be 100 years old. It didn't happen the year before that. All of a sudden, they're going to happen. To that extent, and this is not a judgment on any department, to that extent, it is arbitrary. We have to make decisions. We have to make timelines. We have to do that in order to follow through on our goals. But it falls through the cracks when it comes to individuals.
Okay, if you're asking me as a mover, what I see before me is an order to mitigate unsafe conditions from October 7th. And the public service did put a timeline on that, all things being equal, and there was no appeal for essentially a month later on items 1 through 4. And then another timeline was in January. So do you have a point that is different than those timelines?
Yeah, I do.
That would gain the support of the motion?
Well, that's a good point.
Yeah,
I
what would
don't know,
that
we're
be?
looking like a compromise, something like, how many months are we given here then? How many months are they given?
1.
1 month?
To
Yeah,
get
I'm looking
lots
at
of work
more
in
like
order.
over a year.
Okay,
That's where I'm coming
then
from.
I'd be out.
Okay.
Okay. So do you want to call the question, and if the motion fails?
Well, that's right. Okay, so what I just heard is, okay, so somebody's asking for a year. I would point out that we do know that when inspections come, like the fire escape, like all those codes for people living in there, apparently the escape, the egress and everything is well-defined, all those kind of things. The sprinkler system works. What I see here is that they didn't ask, there's no permits. You have to pull permits in order to do this stuff. Anyway, I'm going to, you have your motion, Councillor Rowland, so I just wanted to speak to it quickly. What I see here is a need to pull permits, and if you pull permits, you can cancel whatever use that room is or whatever. There's the things to be adjusted. It sounds like there was work done around the boiler that makes it safe according to the province of Manitoba, so on and so forth, but the problem is no permits have been pulled. I have a tendency to kind of want to go your way, Councillor Rowlands, in my vote.
Yeah, I bet.
But I see the real dynamic, you know, the hotel across the street just burned down, right? They were having a lot of trouble getting things done to make that building compliant. You could say it's about the money, but really what it's about is if you want to see these heritage buildings saved, and well, not that this one's heritage, but it has a history and a context to it. And the reality is some of today's building code might be impossible. For example, the windows. I don't understand the issue with that, but so I don't know if we're going to get an alternative, but I have a tendency in that you have to pull permits. Sorry, it's the way it goes, right? Like if the work was done already, the safety hazard was done, no permits. Pull the permits and let it be inspected to see if it meets the code. Apparently the changes were done to meet code, so I'm kind of going that way. So I'm just about to make my final decision. I don't know how long that takes, but it sounds to me like the people who are living in that hotel right now are quite safe because this owner does take it seriously and does care about those people despite the things that they go through every day. So I'm going to be voting with you, Councillor Rowland, sorry to say, but so all those in favor?
Aye.
I'm in favor. Those opposed? Councillor Schreier? Okay, is recorded in opposition. So that passes. Councillor Rowlands, would you like to move the final part of the motion?
I would, and I'll move that the representations be concluded and the hearing be concluded.
Okay, all those in favor?
Aye.
I think that's unanimous. All right.
Yeah, thanks very much. I'll take the chair back, and someone will move a motion for,
Please note the committee has made a final
Yeah.
decision on this matter, which is not subject to further appeal.
okay. So appreciate all the time of the public service and those that came to appeal. And I will take away the theme of the day, which is the basic affordability, and in some cases duplication that is calling into question, people's developments and viability of businesses. I will take that away. If anybody has a motion to adjourn.
If I make a statement as well along the same
Sure.
lines, Councillor Rowlands, thank you very much. And these things, we have these appeals, they're close calls. I like to say, there's reasoning why they come into this area of an appeal committee. And I just want to make this statement. It's very important. We've got law and order. We've got rules. We've developed this city, like other cities around the world, with rules. And if you don't have that, what are you creating into the future? When they created this building, as an example, the New West Hotel, this building's lasted over 100 years. There's seriousness undertaking this building over time. And as we go forward in terms of trying to maintain them, or buildings in general, it's going to be the cost. And sometimes the cost comes out like this, and that was what I was trying to avoid.
You shouldn't be talking about the hearing specifically.
Oh, I see, okay.
If you can.
Fair enough.
if
You were
want to make a
talking about
general
the
comment.
takeaway in general is
Just
cost.
take away general.
Talk away in cost, and I'm going to make the
More
point
than one
therefore.
hearing, yeah.
Yes, more than one hearing, and make the point that when it comes to these things, in order to do the right thing, which sustains viability of construction in this city and elsewhere,
Well,
that we will have to contend further. And it's nobody's fault. This is just, well, a greater issue of cost. How do we deal with that in the future when it comes to large construction, buildings like that, when it comes to the necessity, the importance of adhering to building codes and inevitably with building permits and the time needed to adhere to dealing
Motion
with the
to
cost.
adjourn then?
Sure,
From you,
so
Councillor Shire, thank you.
I was going to move adjournment.
Okay, well, consider it unanimous then, and everyone moved. Thanks, Holly. Thanks for your time.